Connected है. Check. Okay. May please, my lord. In 301, my lord, your lordships were pleased to issue notice in the review. My lord, there are 38 SLPs, my lord, which are pending on the same issue, and my lord, in the bunch which was decided on 10th of May, one of those, my lord, went to the other bench. There's notice and now interim, my lord. These two were dismissed in limine, my lord. The question of law is now being adjudicated by a 3-judge bench, my lord.
My lord, may I say something?
That is pending before the bench presided over by Justice Sanjeev Khanna.
That's right, my lord.
No, that is probably
Very well.
that
Very
is
well.
probably listed before Justice Pope, my lord.
Now they want to justice.
Last year,
What we will tag it with the matter which is before
Fair
Justice.
enough.
what happens is this.
Anyway, let one bench take a consolidated.
Right. We have no problem, my lord. What happens is this. My lord, there they say that the review petition is pending.
So lords are finding a way out for that.
Are pending.
And
in fact,
yes. Lords are finding a way out to that predicament.
In fact, it was their duty to tell it to your lordship that the SLP was dismissed. And your lordship wouldn't have issued notice in this matter as well. Because they did not inform. Earlier, their SLP was dismissed. And later the...
Let it be tagged.
Let it
be tagged.
Yes.
Let it be tagged with that. Let that bench take a...
Very well.
Lord, we'll assist. Yes, we can consolidatedly advance our arguments. Yes.
We'll raise our objection, my lord, about maintainability of the...
We are not preventing you from doing that.
Yes.
That bench will take a...
Very well.
Grateful, Lord. I think they're coming up on 17. Yes.
The number, please.
Absolutely, Lord. I'll give the order and the
copy of the SLP has... They need to serve the copy of the SLP.
Give a copy to your...
Absolutely. No, I think we've circulated, but I'll give another copy.
Very...
Thank you.
I'm so deep.
Attorney, you're mentioning something?
Just want to mention a curative petition. We are in the midst of a contempt application. We have sent a request to your lordships. There's a defense estate land in Bangalore where we are asked to hand over possession. So contempt is being heard.
In Karnataka?
Yes, in Bangalore. But the contempt is here. And
sorry, the contempt against the union?
Yes, that's right. So
you want the curative to be?
Curative, yes, your lordship can kindly consider that part.
Lords, may I
ask to just send an email?
We will do that.
Mr. Raggi?
Lord, may I seek your lordships? I'm sorry. No, I'm virtual.
Oh.
After Mr. Rodgi.
Oh. Yes, Mr. Raggi. Yeah.
Application on behalf of state of Maharashtra in a reservation for tribal scheduled tribes will not issue. There's some lot of unrest will not be moved in IA. So we thought it will be taken up at 23, but 23 may not reach. My IA may be taken on Friday.
Friday, Mr. Raggi, there little problem perhaps with the constitution of the bench on Friday.
On a Monday.
So then we can take it up on Monday immediately. Yeah.
Whenever. I'll just give the IA number. It's extremely.
Monday's a holiday.
Certainly, I'll just give the IA.
The others, can you all not circulate emails?
I have.
Sorry.
Right. We'll go from left to right.
Yes.
And
my lord, up.
Mr. Solicitor, we'll deal with the solicitor for a moment.
No, I'm just, my lord, on the lighter side saying left to right and up also, my lord. My lord, we have circulated, my lord, mail, my lord. I'm conscious your lordships always go through it. My lord, this is a case where NCLAT has halted ongoing, well, the High Court has halted ongoing, my lord, CIRP at a stage where we have received the plans.
It's a fresh matter.
It's a fresh matter, my lord. We request for this side of the vacation, my lord. It's a High Court interfering, therefore SLP.
I'm sorry, Father. All right, I'll just look at it in the evenings.
And if it can be on Thursday, because Friday bench may not be.
The demolition matters are before the court 3. This is the demolition of a nearly 1,000-year-old dargah in Gujarat. I filed a contempt application. The urgent orders required primarily because everything is sought to be finished and a road is being built on that.
When was the impugned order passed?
There has been a demolition. The impugned order is of this court. And
Yes. Mr. Giri, just send an email. This could have just been said in one para. I would have
sent an email.
When?
In the morning.
Today in the morning. The purpose of an email is not to sort of say, okay, I've sent an email and I'll mention. Purpose is to obviate mentioning.
I'm sorry, but
it will be dealt with by me. Yes. Yes.
Sir.
Obviously, say the same thing in the email.
The bench is sitting ready.
Right. We'll see. Yes.
Urgent anticipatory bail. Can it come up on Friday? That's one, my lord. Urgent, because it's political in Telangana. We'll be arrested. I have sent it. I have sent everything.
Again in the morning.
Morning and yesterday, my lord.
Oh,
both.
Not
physical.
It
was given physical also, my lord.
Huh?
Order is up.
My chamber last night at 8 o'clock. Until 8 o'clock, all emails were dealt with by
Last night
Nothing
the order
was
got-
sent until 8.
So
all emails until 8 o'clock had been dealt with. I had like a sheaf of.
I know, my lord. I'm not troubling your lordships with that.
I'll
I'm only
deal with
praying,
it.
my lord,
I'll
that
deal
if
with
it,
it.
because we are breaking for holidays, my lord.
No difficulty. In fact, because I don't permit oral mentioning, I'm more liberal on emails. I can assure you that.
There's just one other mention before Justice Pardiwala, my lords, and a bench comprising of Justice
Yeah.
Pardiwala and Manoj Mishra, my lord. Medical bail, your lordships have been pleased to issue notice, my lords, and that has not got returnable and it expires today. That has not got, can I just pass on the order, my lords, for a moment? 3 copies. Lords and some.
Have to surrender on which date?
No, we are in custody only, my lord.
You have been taken back in custody.
We are in custody, but if
Then you will have to file a fresh.
we are in custody only, this fact was for regular bail. Your lordships have been pleased to notice in regular bail application of mine.
Friday.
Lordship, please.
On,
We will be in this
Yes,
company.
Manoj, on 20th of of September, my lords, your lordships had directed a matter to be listed today. This was that in international commercial arbitration where concurrent findings were set aside in a 37 order, my lords. And this was your lordship's order for today. On that day, my lord, the Chief Justice was not holding court after lunch. So it came up before a bench of Justice Patiwala and Justice Mishra.
So it has to be listed.
Yes, my lord, because it was to be listed today, and our difficulty is the precarious condition of the judgment debtor in that matter, my lord. This was the order passed for today.
You are for the respondent.
Yes, and for the petitioner.
Okay, we'll list it. Now, maybe this side it may be a little difficult.
I will not press that, my lords. I am conscious, but on after the Dasahra vacations, my lords.
Yeah,
So, my lords,
Very grateful.
brave leave to mention a matter. I have done 4 emails in the past, and the 5th one on the
It's a fresh
26th.
matter? Fresh matter?
Yes, my lords. My lords, it's an after notice matter. My lords had kept it only to explore if something could be worked out between the corporation and us. We are small buyers of shops who came together and took it in the insolvency proceeding from a developer who had gone into insolvency. My lords, we put in 200 crores and we are stuck.
I'll look at your email today. I'll look at the email today. After notice, the difficulty is this. Normally, I give liberty to mention before that bench because, merely because it is mentioned, I can't give a date. Otherwise, older matters never reach. Only the matters the lawyers pick out get heard in the court. That's the thing.
Say something.
After
it's only a small modality. It won't take more than 10 minutes or 5 minutes. I really request, my lords. Just pass it to the court master so that my lords. Giving it to the court master so that my lords have a reference to the
You have the email, no difficulty.
It's
Yes.
26.
My
26.
matter is already on board at number 26 today. I know your lordship's board is very busy, my lord. There's that RDF IA, my lord, I've been yearning. Now my season has started today. And the infrastructure of the mandis in agrarian society like Punjab is in dilapidation, my lord.
Already might give some higher position after we. Just remind me today.
A little higher in the sequence, my lord. I'll be deeply obliged.
Item 30 on my lord's board today, that's the West Bengal OBC matter. We are for the impacted, my lord, even scholarships are being denied, although that was a reservation judgment. So, my lord, maybe you lordship list it on Monday, my lord, Monday if possible.
I've already said that after the vacation, mini vacation will give it priority.
Monday won't be possible, my lord.
Monday's court is closed next.
No, on reopening.
On the reopening.
On the reopening.
Yeah.
Yes.
It's a fresh matter.
Fresh matter will be listed in accordance with the circular.
It's very urgent.
What is the urgency?
10 similar petitions are pending and no coercive orders has been passed by this honorable court. My
When was the impugned order?
Graded ballots under the impugned provisions of GST.
GST. When was the impugned order passed?
There's no impugned order. This is the fresh writ.
That's all right.
Everybody has come.
32 rate. Everybody is running here. Challenging one provision and getting coercive. We've seen that. You know what is happening in these matters. It will be listed.
Your Lordship.
My lords, are mentioning writ petition 114 of 2014.
My 15 petitions are pending before this.
That's all right. I'll pass an order, but you can't just get it right now because you say coercive steps. Look, you know, and I know what happens in these matters. Let me not be obvious in the court. I'll get it listed. That's all right. Okay.
My lords, are mentioning writ petition.
Just one.
My lords, please my lords, are mentioning writ petition 114 of 2014. It was mentioned yesterday too, and my lords was pleased to give a date of 15. My lords, can be listed prior to the Dasahra holidays, my lords, because our lease was lapsed on 11/10/2023.
Yesterday it was mentioned.
Yes, my lords.
Why do you mention it again? I've given a date.
My lords.
This bench is not available on Friday, so therefore I've listed it on the 15th.
My lords may protected, my lords, because there was a condition.
Yesterday, merely because you can't have this kind of thing. These are all mining matters. Another thing, we're not going to pass an order without reading the papers.
My lords, my mining lease was lapsed, and the leaseholder will be remedied.
It will be left. It will be heard on the 15th. What will happen?
It will lapsed on 10th of this month.
That's all right. We'll restore it if we find that there's equities in your favor or the law is in your favor. But nothing without reading papers. We do not have time until Friday. It will be only after the Dasahra break. Yes.
But I'm so sorry.
Stop this practice of repeated mentioning by different counsel. And just trying to take a chance. Whatever little discretion I have as a Chief Justice will never be exercised in your favor because it's an attempt to take the court for a ride. Get 3 different counsel and see, if the judge blinks and get an order. That's what's happening in this court, and I'll not do it. Because my personal credibility is at stake when I do not follow consistency in listings.
With your lordship's kind permission.
Yes.
There's a matter, my lord, the power of the state governments, my lord, to appoint a vice chancellor, my lord. Your lordship heard it in part. It came up on 13th of August, but unfortunately, the airport's economic regulatory authority.
We'll have it placed immediately after the Dashera.
Your lordship's kind permission to mention item 32 on your lordship's board today. Your lordships are busy with the Jet Airways matter. Your lordship, it's a withdrawal matter. I've filed a...
It will be called out. I've got that. It's to be withdrawn. It will be called out before.
I appear for the respondent.
Just wait for 5 minutes.
May I pledge you, lordship? Your lordship, it is a fresh anticipatory bail. The petitioner is
not mentioned. The matter will be listed. When were defects removed?
Defects is already removed.
When?
Today, yesterday, your lordship.
So it will be on board. It will be listed on Friday. There's a circular of the registry. If only you follow rules, there's a circular of the registry. If defects are removed before Wednesday, it will be listed immediately on Friday.
I bow down, your lordship. Your lordship, petitioner is a senior citizen lady, your lordship.
But I'm telling you, Baba, it will be listed.
Oblige, your lordship.
Just see the circular. Padho thoda sa.
Your lordship, I am mentioning after notice matter. This was there was a fixed date. This is that matter of acting DGP in Jharkhand that was appointed. There was a fixed date, but bench could not sit. We have given 2 letters, your lordship. Much offense.
Please, my lords. My lords, I have instruction from my client to withdraw this petition. Your lordship, the matter has been settled, lordship.
Yes, my lords. The matter has been
withdrawn.
Grateful, my lords.
Your lordship, this is a Canadian entity which is undergoing insolvency under the Canadian law. The receiver has instructed us to withdraw this petition.
All right. Dismissed to withdrawn. Item 4. To dismiss in default.
Please, my lords. My lord, this is a section 11 petition, my lords. The respondent have entered appearance. They have not filed their reply, my lords.
Is that true? Yes.
My lord's arbitration clause at page number 100.
We appoint an arbitrator.
My lord, this invocation is not in terms of arbitration clause. May I just show page?
This is arising out of 2 purchase orders of 2018 for some incinerator package, right?
Please.
And on 2011-18, you issue a termination. On 6/12/19, you issue a letter demanding 67 crores.
Lord, may I just show?
And the demand notice is of 12/7/19, right?
Please, my lord.
And even invoked arbitration on 5/9/19. Why is it not in terms of the arbitration clause?
My lord, the arbitration clause has been amended by them only at page 108.
Yes. Let's see that.
Your lordship have that bottom of that page.
Annexure?
Lord, it would be
P1, my lords.
P1 itself at page 108. Your lordship sees at the bottom of page 34.1.
This will be.
It has been amended to arbitration by an arbitral tribunal comprised of 3 arbitrators selected in so and so accordance with. And if your lordship sees the invocation letter and the final invocation, which is P33 at page 392, my lord.
P33.
At page 392.
But they have sought a sole arbitrator.
Sole arbitrator. Please, my lord.
What do they say? Sole arbitrator.
Yes.
Therefore,
they want to appoint their own arbitrator only, as per this.
Why don't we do this?
Let them appoint one.
Why don't we do this? We can, if you are both agreeable, you have a sole arbitrator instead of having 3 arbitrators. And how much is the claim?
My lord, 13 crores.
1-3.
1-3.
Lord, may I request only for one thing in this matter? I am for R2, I am a subsidiary, and the principal company was under liquidation. I have not received some comments from that Belgian company. may just keep it after vacation or any day on 12th or something. I'll be ready with
You are seeking arbitration against the principal company also?
Principal company.
They are also party to the arbitration
They
agreement?
are also party to the arbitration, my lord.
In fact, my lord, all the notices, demand letter, everything has been issued only against the principal company, nothing issued
You
against.
are the Indian subsidiary.
I'm the Indian subsidiary.
And is that Belgian company under liquidation?
My lords, I am not aware, my lords.
Go and say. Then you may have to implicate the liquidator. Liquidation is of the Belgian company.
Belgian company, the principal
The
company.
principal. Can you just find out, because then we'll have to implicate the liquidator and then pass orders.
My lord, can we do it after
All right.
vacation?
We can keep it after the vacation. On behalf of the second respondent, states that his instructions are that the first respondent, which is the principal in Belgium, is under liquidation. However, seeks a short adjournment to place this on the record. List on the reopening.
Much good.
This is a petition to appoint an honorable arbitrator.
Please, my lords, we have no objection.
How much is the claimant? 6?
It may be roughly around 7 to 8 crores, $870,000.
My lords, the seat is in Bangalore, so a Bangalore-based arbitrator may be appointed.
Arbitrator to Bopanna as a point. He'll appoint Justice Bopanna as the sole arbitrator. Is that okay?
Right.
So, Justice A.S. Bopanna, former judge. By the way, वो slip दे दो आपका, वो जो. By the way, I normally don't, we never skip the board, but item 31 is a bail application.
Yes, my lord.
Then withdrawal is 32, fresh 3 matters, 33, 34, 35, after which we'll start the Jet Airways part.
Coming after notice, I'm in custody from the last about 13 and a half months, my lord.
Who's appearing?
Investigation is still pending.
Yes. Raju was appearing. He's not here, my lord. If it can be on Thursday or some other day, my lord. If
Tomorrow.
Oh, tomorrow is second.
Yeah,
Thursday. We take it up to the Thursday.
Can it be a week, because he's not available for the week? Otherwise, we'll have to make some arrangements.
If it will go, then by another 12
I
days.
leave it to you.
The
Take
13
it
and
up
a
on
half
Thursday.
months in custody investigation is going on, my lord.
Thursday we'll take it up. Thursday.
So we'll make some arrangements.
So good.
Because Mr. Anturkar is appearing on VC for the respondent.
Lords, I appear for the respondent. The petitioner has moved a I for withdrawal.
I have moved an application.
Dismissed as withdrawn there.
Grateful.
Item 33.
That medical. Sorry?
The petitioner before your lordship is private management B court under.
क्या बोल रहे हैं?
He says petitioner is a private management.
What only the petitioner before your lordship, my lord, is seeking under B management court under. Same 3 posted of third, my lord. Tag with
So we'll tag it with the main.
notice. Plus.
Well, this arises out of a foreign award. I seek enforcement in the Madras High Court before the single judge. The opposite party refuses to pay under the award. That amount is due on the 3rd of October. Against orders of the learned single judge, granting some interim orders, injunctions from them from restraining assets, and acting in terms of the award, an appeal is filed. Ex facie under Section 50 of the Arbitration Act, no appeal lies against. I'm sorry.
So the appeal does lie, and how do you interfere twice in an award, international award like this, with great respect for this?
Yes.
Just kindly consider 3 things for this. Firstly, there is a 1400 crore international award contested in my favor.
That's for 5th of July 24, right?
That's of which 660 crores is mine, and the balance 800 is by other investors. We all invested in this company. There's an exit clause that if you don't do by a cutoff date in 2016, then you have to do either of 2 things. There'll be a strategic sale,
allowing me an exit to recover. Strategic sale is a defined term which says that you must give me information to enable me to sell. This is not a listed company. Your lordship goes to the share stock and sells. So they have to give me information. Now, having suffered the award, they don't challenge the award. I go for enforcement in 47-49. It is pending. In the first round, I say that while it is pending, stay alienation of immovable assets. The learned single judge passes an order with 3 paras, para 12, 1, 2, 3. Just note that at the learned single judge order at PDF page 477 or at 485. Learned single judge passes a very reasonable order, which your lordship always does. I have a thumping award of 1400 crores. You can't alienate. So page 485. PDF. Interim injunction restraining 2 to 5 from transferring, selling, pledging, encumbering, dealing, or otherwise disposing of. Second is interim injunction of 2 and 3. Well, 4 is not really contesting this. PDF is 480.
And the judgment, what annexure would that be?
485 is the PDF. Annexure should be annexure P7. P7. PDF page I am giving.
Yes, you got it.
Slightly more trained in PDF pages, so you used to forget that otherwise. So the second direction is, I'm sorry, just keep it here, just transfer because these guys just told me the
it says interim injunction restraining R2 to 5 from transferring, selling, pledging, encumbering, dealing, or otherwise disposing.
At least you will do with an award of 1400. Second, restrain in any manner dealing, encumbering, either disposing, dissipating, or creating third-party rights, including the properties disclosed in Sasha. Sasha is the share agreement. And third is, keep a copy of the note, this note. And third is important. This is not challenge and appeal. Third, just note this third one. Right?
Yes, sir.
My lord has got third one.
Third is
nobody one challenge. In charge, other than the nominee directors, are directed to take such actions as may be required, including cooperation and providing unrestricted access of first information document. This is the crucial one because it's only for sale. I am already a 20% holder. I cannot sell without information. A strategic sale means that the price should not fall. So you have to give information out. So this is that innocuous. Malas said this is carried by the other side to the division bench and come to Malas 12th of August. Don't go, not go to the actual document. It's much simpler on this list of dates. Just 2 minutes it will take. Same thing. Give it to the other side. Give it to the other side. In this, Malas, your lordship has covered item.
Give me that. It is also not maintainable.
Yeah, correct. I'm just coming to why the appeal is not maintainable. Well, this is challenged on 12th of August 24. Lordship has got that? Your lordship has just dealt with the single judge, which is the earlier order. This is challenged. The division bench on 12th of August does actually nothing except saying remand it, which is wrong, of course, because you, the learned single judge, decide maintainability of my enforcement and interim application. I hope I'm clear on this.
The learned division bench demanded the mandatory single judge to decide whether the interim application filed by the petitioner were maintainable, whether enforcement petition was filed prematurely. All right.
I'm grateful. Now,
and then upon remand, there's an order of the 3rd of September by the
Now, this order, again, just read this item with me, 3rd of September, passed an order deciding issues of maintainability and of enforcement petition in my favor. It was inter alia contended by R1, the opposite side, that the Arbitration Act is a self-contained code and the applications are not maintainable until we reach 49, which means that once your lordship reaches 49, he can dissipate. I hope I'm clear on this.
Yes.
Till the enforcement objections are decided, he can dissipate what he likes. It's an extraordinary proposition. It was held that the interim application in the present case substantively invoked provisions of Act akin to provisions could not be a mere technicality. Therefore, this order in my favor extends the interim order till 4th of October. A second time, unfortunately, the learned single judge, the division bench grants a stay. Now, just come to my note below. This will be simpler. First of all, the appeal to the division bench doesn't lie. Well, just come below to summary of arguments. My lord, straight away to be easier.
Yes.
Now, just see, the learned single judge's orders are not appealable. I'll show the section in a minute. It's a foreign award under 44. Therefore, you can appeal only under Chapter 1, Part 2. 50 is the section, lordship will note on the next page. It allows appeal only against orders refusing to refer the parties to arbitration under 45 or to order enforce a foreign award under 48. Learned single is there neither. I hope I'm clear, Manus.
Yes.
Just see 50 for a second, Manus. Lordship doesn't mind. and the judgment is directly on point, Your Lordship's Kandla.
We got it here, yes.
All my three lords have it. It's on the screen also. Not, Your Lordship knows this has that word only, all these.
Refusing to refer or refusing to enforce?
It's common, well, I will not say common, it is obvious that it is neither of the two categories. Your Lordships in Kandla, in para 17 to 23, which is listed in my para B, have directly upheld this interpretation. Learned division bench, I distinguishes it on the argument.
Did you cite Kandla before the division bench and raise this issue?
Cited as an argument. He notes the argument, says the other side has argued this. 1, 2, 3. I accept it. Gives no reason of its own. Now just see that chart first. That will make it easier. Give it quickly. What it does on Kandla and on the other cases. May I just finish this note first? This is first is important. Yes. We'll just stick to. Now, what you cannot, now, 50 does not permit an appeal against an order enforcing an award. Then surely it cannot be held that an appeal against an interim order is maintainable. I hope I am clear with this.
Yes.
Then, next point. What can it be done directly, indirectly? In view of section 50, now they say that we have filed the appeal under Commercial Courts Act. If Commercial Court Act's appeal are maintainable, then 50 become nugatory. I hope my lord is clear with double I. Kandla is this only, that a special act, arbitration act, can't be nullified by general right to appeal under section 13. Commercial Courts Act, section 13.
LED 13.
Is Fury still?
Restriction in file appeal. Only there is no appealing program. Unless 30, this 50 has the
Now, but I want to just show the next 2 points to Lordships. Section, Kandla, following Furist Lawson. 3 things directly in the teeth. Now, let's just see the next point and I'll show what the learned division bench did in a minute. Would my lords turn to my notebooks?
Except the provider to 13 months.
Well, Arbitration Act can't be overridden. It's a non-obstant clause.
Commercial Court tells you the forum, but
whether an appeal lies or not is not decided by Commercial Court, brothers.
says the enforcement will go.
The Commercial Courts Act tells you the forum. It doesn't decide whether you can appeal or not. Whether you can appeal or not is decided by a substantive provision called 50 in a self-contained code, Arbitration Act, with the non-obstant clause. With a non-obstant clause. Yes. Whether in an arbitration matter you can appeal or not is only governed by this act, not by the Commercial Courts Act. Commercial Court is saying the forum must be the Commercial Court.
Yeah,
notwithstanding anything contained in any other law. My lord has not got it.
Yes.
Notwithstanding anything contained in any other law for the time being in force.
Yes.
An appeal shall lie from the order refusing to. I'm sorry, the Honorable Chief Justice doesn't have it. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the order refusing to refer the parties to arbitration under 45. That's not the case here. Enforce a foreign award under 48. That's not the case. It is pending. to the court authorized by law to hear appeals from such order. No second appeal shall lie from an order passed in appeal under this section. He can't entertain it. Whether your lordship will have an appeal. Sorry, my apologies.
22 and 25.
Will the copy to them? Copy is not. Things. Para 22 of Kandla and then see 48.3.
Let's see what Kandla said.
Para 22. And then see what the division bench says. Kindly give. Well, as in this bunch, is page 18.
That's a big one, I suppose.
I'm only reading the relevant part. Manas. My lord has got Manas, para 22 at page 18.
Para
22.
Yes.
This in fact follows from the language of 50 itself. In all arbitration cases of enforcement of foreign awards, it is 50 alone that provides an appeal. Having provided for an appeal, the forum of appeal is left to the court authorized by law to hear appeals from such orders. This is important, Manas. Commercial court will send you to a commercial court if the appeal lies. 50 properly read would mean that if an appeal lies under the said provision, then alone section 13(1) of the Commercial Courts Act will be attracted as laying down the forum which will hear and decide service. That's the correct way of looking at it. The Lordship has the Arbitration Act which governs, not the Commercial Courts Act. It doesn't know about arbitration at all. It is only on forum. Now, Manas, para 20, little before, it follows Furus de Lawson.
Just 1 second. 20.
20.
Yeah, just read para 20.
Yes. Given the judgment of this court in Furist Lawson, which Parliament is presumed to know when it enacted the Arbitration Act of 15, and given the fact that no change was made in 50 of the Act when Commercial Courts Act was brought into force, it is clear that 50 is a provision contained in a self-contained code on matters pertaining to arbitration and which is exhaustive in nature. It carries the negative import mentioned in para 89 of Lawson that appeals which are not mentioned are not permissible. This being the case, it is clear that 13 of the Act, being a general provision vis-a-vis arbitration appeals relating to appeals arising out of commercial disputes, would obviously not apply to cases covered by 50. Now,
however, the question still arises.
37. However, may I read that?
Yes.
However, the question still arises as to why section 37 was expressly included in the proviso to 13(1), which is equally a special provision of appeal contained in a self-contained code, which in any case would be outside 13(1) of the Commercial Courts Act. One answer is that this was done ex abundanti cautela. Another answer may be that as section 37 itself was amended by the Arbitration Act of 15, which came into force on the same day as the Commercial Courts Act, Parliament thought in its wisdom that it was necessary to emphasize that the amended 37 would have precedence over the general provision of 13(1). Incidentally, the amendment of 2015 introduced one more category into the category of appealable orders in the Act, Arbitration Act, namely a category when an order is made under 8, refusing to refer parties to arbitration. Parliament may have found it necessary to emphasize the fact that an order referring parties to arbitration under 8 is not appealable under 37(1)(a) and would therefore not be appealable under 13(1). Whatever may be the ultimate reason for including 37 of the Act, Arbitration Act, in the proviso to 13(1), the ratio decidendi of the judgment in Furus de Lawson would apply. And this being so, appeals filed under 50 would have to follow the drill of 50 alone. And then they add 22, which I also just read.
Read 25 and 26.
Yeah, 25.
I'm grateful.
25.
25 and 26. What is important to note is that it is section 50 that provides for an appeal and not the letters patent given the subject matter of which is DB, which deals with these 3 cases. Here's this point, DB. Also, the appeal has to be adjudicated within the parameters of section 50 alone. Concomitantly, where 50 excludes an appeal, no such appeal will lie. No such appeal will lie. In the view of this case, it is unnecessary to advert to Sri Giri's arguments based on section 21 of the Commercial Courts Act. 21 would only apply if 13 were to apply in the first place. which has been found cannot be held for the reasons given above unnecessary to advert to the arguments for 11. The matter can be looked at from a different angle, verse 27.
So the purpose of speedy disposition.
The next para. The whole purpose of speedy. Now, let's go to the merits for a minute, then come. 48.3 scheme, merits. (27) I just read, Willis. Sorry, I was about to read. My lord is right. The matter can be looked at from a slightly different angle. Given the objects of both the statutes, it is clear that arbitration itself is meant to be a speedy resolution. Equally, enforcement of foreign award should take place as soon as possible. I have an award from 2022. If India is to remain as an equal partner to the international, commercially speaking, in the international community. In point of fact, the raison d'etre for the enactment of the Commercial Courts Act is that commercial disputes involving high amounts of money should be speedily decided. Given the object of both the enactments, if we were to provide an additional appeal, when Section 50 does away with an appeal, your lordships in the legislature intends don't give an appeal and your lordship provides the appeal. We would be turning the Arbitration Act and the Commercial Courts Act on their heads. Admittedly, the amount contained in a foreign award is to be imposed. That's a separate matter.
Is there a negative stipulation implicit in 50 according to you?
Yes.
50, what 50 does is, it says notwithstanding anything contained in any other law
I'm grateful.
the timing in force, an appeal shall lie against the following in the two categories. An order refusing to enforce.
So it specifies.
Yes.
It specifies. And it starts with non-obstant. Plus your lordship has a judgment directly on point. Now, it is mixed up with the Commercial Courts Act, which provides a forum. Suppose Malas 50 gave you an appeal. You would go to a commercial court, no problem. You won't go to a non-commercial court. If did not give you appeal, you'll go to whichever is the commercial court available. Now, let's just see how the impute order deals with it. This is very interesting. Yes. But I must tell you something startling on the merits in a minute, because all this appeal will not get me anything. What they are doing is today, by a clear default and an award of 1400 crores, they have to give me only information for me to start the process of strategic sale. They don't give me information.
They have to pay.
That's the stay which is operating against me.
They have to pay by 3rd October.
They have to pay by 3rd of October under the order, which by the division bench is now Malus state. Now come to the impugned order. Is this the way, Malus, with great respect, to deal? Only the contentions of the other side are noted, and it is said, I accept them.
Now, where do they deal with the maintainability of the appeal specifically?
Para 8. That's what I'm asking lordships to go to. Justice Padiwala has got 8. Justice Mishra has got 8.
At page?
Page is 7. PDF should be 34.
Para 8.
Para 8. Just 8 to 10. That's it. Actually, no decision. It's only a contention noting and then agreeing. Learned counsel for appellant, that is the other side, submitted that Kandla is a matter where, on facts pursuant to a proceeding in UK, an execution petition was filed in a district court in Gujarat, and thereafter the High Court transferred the execution petition to Gujarat High Court, after which the Gujarat High Court dismissed objections under 48 of ANC. Dismissal of objections under 48 is not appealable under 50, and Kandla is a case where what is expressly unavailable under 50 was sought to be filed by taking 13A route. It was also argued that Kandla is a case where 50 was clearly unavailable. At 50 will be available only if 48 objections had been allowed. Where do you get this from us? So 50 is available in 48, but an interim order is available under 50. Well, just kindly pause here. It means that 50 will lie when a final 48 is passed, but will not lie then, but will lie when an interim order is passed. It also emphatically and respectfully submits that Kandla is not an authority for a case where an appeal is preferred, complaining that the impugned decision is without jurisdiction. It was reiterated that in Kandla what is barred by 50 was sought to be reinfused by way of 13. It was also submitted that Kandla is a case where all contentions only of 48, contradistinction on the hand, etc. without jurisdiction. Then Malas? No.
But they say in Paratin, in the light of narrative discussion thus far,
yes,
this CAD.
No, but just read 9 also, just 9.
Grounds to say that this CAD is prima facie satisfied.
Yes.
That the appeals are maintainable, but there's only a record of prima facie satisfied.
Not only that, it is not a record, Malas. It is a record of Mr. Sundaram's counterpart's contention without any reasoning of the High Court.
Why is it without jurisdiction?
Malas, these are contentions.
Contention.
Now, let's before that. Now let's see what the practical reality is. Asma Latif, you man.
Reference in 13, the proviso to 13(1)(a), there's a reference to section 37, but there's no reference to section 50.
The scenario deals with it in para 21.
I saw that, yes.
He deals with that precise point. He says there could be many reasons. But one thing is clear, the controlling authority is 50. And that's the right way to, otherwise the Lordship Malus will find that 50.
You know, there is a little difference in terminology between section 37 and section 50. Because 37 and no others.
No others, correct.
50 doesn't use the expression.
But that is why it has been interpreted now. It has been interpreted now
by this
judgment. And Malus, this is not a fair way of dealing with this judgment in the DB. Now, one more para I forgot to mention. Para 19 is the only other para of the DB, which I should have mentioned, which deal with it. And then I want to show the practical realities that your Lordship should know. I don't want to argue an abstract point of maintainability without your Lordship knowing what's happening on the ground. Come to para 19 of the same implement order at page 18 or PDF page 45. Lordship has got that? To buttress the prima facie satisfaction, we also say that if same proceedings, albeit without jurisdiction in the light of explanation to 47 and 54, were in a district court, this court can be approached as a power to sue is available under 227. Whereas owing to the proceeding being before commercial division cannot be gainsaid, that this CAD cannot be approached by way of an appeal. Well, when you have 50, you can't approach by 227s. Why are you turning it around? Exactly. So what? have your lordship seen this para? Well, is that para 18 of Kandla also addresses, my lord, the Chief Justice's point in more detail. I've already read 2021, but this is more detail. May I read 18, Malas, for my lords? That's the query the Honorable Chief Justice put in my case compilation, page 15.
This distinction was dealt with in law.
Yes. One of the submissions made before this court is that in the identical submission of Sri Giri before us, 37 contains the expression and from no others, which is conspicuous by its absence in 50. This was answered by the court as follows. Para 60 and 61 ones. Next page. It is also evident that part 1 and part 2 are quite separate and contain provisions that are independently in their respective fields. The opening words of 2, that is the definition clause in part 1, make it clear that meanings assigned to the terms and expressions defined in that section are for the purpose of that part alone. 4, which deals with waiver of right to object, is also specific to part 1. 5, dealing with extent of judicial intervention, is also specific to part 1. 7, that defines arbitration agreement in considerable detail, also confines to part 1 alone. 8, deals with the power of judicial authority to refer parties to arbitration where there is an arbitration agreement. This provision too is relatable to part 1 alone. Corresponding provisions are independently made in 45 and 54 of part 2. The other provisions in part 1 by their nature shall have no application insofar as the 2 chapters of part 2 are concerned. Once it is seen that part 1 and part 2 are quite different in their object and purpose and the respective schemes.
It doesn't.
There's 2 minutes. No, this is the law part. 2 minutes more. The actual reality on the ground. Just 2 minutes more. Turn to my list of dates on the top of the note, fellas. This is important to know because this maintainability gets nothing, fellas. It just he perpetuates an interim stay. Remember 3 facts, fellas. He has not challenged the award. The main enforcement is pending. It's an interim order for a strategic sale. Please come to item 2. This is 5/7/24. My lord, this is Mishra has got it. Yes. My lord, this is Pardiwala has got it. Number, this is very important because on the ground of this law, you are more or less doing what on the ground? The SIC tribunal issued its final award on 5/7, awarding the petitioner, that is me, and other investors 1400 crores.
Where are you reading this?
Well, in my note of the
item 3.
The second item.
Second item.
This is the reality which you should know.
Yes.
Not in the abstract. The SIAC arbitral tribunal is full hearing, detailed hearing, etc., awarding the petitioner and other investors 1400 crores, out of which 661 is payable to me with interest of 5.33%, not a very high interest. Further, upon the respondent's failure to make the payments within 90 days, now this is 4 clauses. The petitioner and the other investors will be entitled to proceed towards a strategic sale as contemplated by Sasha to be complete within 6 months of the final award. Now just note, above that, just above the list of dates, 1 para more, I'm sorry to trouble, just 1 para above. D. The company and the promoters were required to ensure that a qualified IPO took place before the cutoff date of March. Clause 19 of Sasha says that if this was not contemplated, the investors became entitled to avail of an exit waterfall. The company failed to provide and it constituted a material breach. Now, Malas, the result of this is that they have to disclose information which I will then use for a strategic sale. The last board meeting was 3 days ago on 27th. In the board meeting, they refused to disclose, saying we have a division bench order. Not disclosure means that to buy such shares, this is a very well-known company. I am a very well-known company, the Azim Premji Group, which does in startups. They cannot go and look for buyers. Forget getting a buyer. Buyer will take few weeks. They don't give me the information by this point.
My lord, 3 very important facts have been glossed over.
They are supposed to pay me
which changes
by
the
3rd October an amount of what? 661 crores.
My lord, can I answer straight away?
How is the
3, just 1 moment, my lord. 3.
How is the appeal maintained?
I'm answering, my lord. My lord, there
are 2 judgments against you. One,
my lord, I'll explain why.
One in Kandla. And
I appreciate that,
Lawson.
but I'm explaining why and how. And some 3 important facts I need to point out to my lords. My lords will do. Statement made we have not moved to set aside. The award was passed on 5/7/24. I have 90 days in Singapore to move to set aside, which is 5th October 24.
Move there.
A. 2. Page 4. Both parties moved for correction of the award. The corrected award was passed on 22/8/24. These dates are important. My time, my lord, if I go on 22/8/24, I have 3 months to move to set aside the award. If I take the date as 5/10, I still have 3 months. My learned friend says hasn't complied, hasn't moved to set aside. Now, first question which arises, that's why the learned judge says, I am finding prima facie, page 23, he has posted it to 17/10/24 for hearing. This is not a final order. He's repeatedly says prima facie. Now, the second important point, my lord, I'm coming to the second point. My lords, kindly see what was done. Please take section 48.5. I'm just giving these important facts and then I place my submission as to how it would be maintainable in this case. My lords, Arbitration Act, please see section 48.5. My first submission is the 3 months for setting aside the award has not expired. How do you move for execution? If, for example, under 34, I have 3 months, you cannot move for execution till the 3 months has passed. Now, how do they move for execution at all? Secondly, they ask for an order under section 48.3.
Kindly read that.
My lords, I'm saying firstly, their petition under 45-47 was not even maintainable for 3 months. All right. They then file it. Then 48.3 says, if an application for setting aside or suspension of the award has been made, that is after I make my application to set aside, let me give them the full hilt. It's available even before I make it. Then, the competent authority referred to may, if it considers proper, adjourn the decision on the enforcement of the award, may also on the application of the party claiming enforcement of the award, order the other party to give suitable security. Here, 3 orders were passed. 1, of injunction against me, disposing. 2, to ensure that those properties were kept. 3rd was a mandatory order in implementation of the award, which cannot be passed under 48.3. Please see, my lords, and the only part, and that's a 3rd error of fact stated, the learned judge says it's only, I'm not dealing with the first 2 injunctions, they continue. This appeal is directed, please see page 6, paragraph 6. Page 6, paragraph 6. As already alluded to supra, page 6 of the order, though interim injunctions have been granted and the same are operating, for the present, interim direction alone is the epicenter. Malad, there were interim injunctions for protection of the assets passed. The third...
Those continue to operate.
Those continue.
Now, what is the operative order which has been passed?
Is number 3, which your lordships will find in the impugned order. It is found, my lords, at page, I'm just showing your lordship it's in the judgment itself. Page 13. Page 12. My lords, the cause of action even to demand a sale does not arise unless I don't pay in 90 days.
Now, where is the operative order? We make the following interim order.
Kindly see page 13.
1 to continue.
Page 13. This was the order of the single judge.
Right?
Yes. Interim injunction restraining respondents 2 to 5 from transferring, selling, pledging, encumbering. That continues. That's not the subject matter. 2. Interim injunction restraining respondents from any manner dealing with, encumbering, disposing, dissipating, creating third-party rights, alienating any immovable, movable property or assets. The third is in implementation of the award, which cause of action arises only if I don't pay in 90 days. And 90 days is 22nd November. Only if I don't pay by then. Respondent 1.
Now let's just see the operative order of the division bench.
Of the division bench.
Page 19. Interim direction made with a 1 impugned decision and extended.
Yes, that is, my lord, see, earlier, the learned single judge had passed 2 orders, both on the same direction. Interim direction, that is what I just read to my lord, number 3, and extended has been extracted, reproduced. Supra, there shall be interim stay of this interim direction till the next listing. To put it differently, interim suspension of this interim direction till next listing, which is 17th October. As regards interim injunctions Quay 1 and 2, the same will continue to
So what
operate.
they have basically done is that they have maintained the division bench,
Yes.
maintained the injunctions, but only stayed 12-3.
Which is an enforcement of the award by saying, my lord, what did the award say?
And your time for challenging the award is still
It's still there. And lastly, I request your lordships to consider whether 136 should come in here when page 23, it's listed on 1710. And the learned judge has specifically said at page 11.
Dr. Singhvi, I mean, there should be no lack of clarity on what the division bench has done. They have maintained the injunctions on the alienation of assets. They have only stayed 12-3, which was really a disclosure to be made of data, etc. by the.
Not more than disclosure, it was to facilitate the sale.
For the
facilitate the sale.
Now, second, the award today. I mean, can we say that the award is enforceable because they have 90 days time to file an appeal?
Three things. One, 48.3 contemplates interim orders. It's
Of
a
security.
Can I just
Only security.
48.3
application for the setting aside. One second.
Interim
If
order.
an application for the setting aside or suspension of the award has been made to a competent authority referred to in clause E of 1, the court may, if it considers it proper, adjourn the decision on the enforcement of the award and may also
On the application of the party claiming enforcement,
but there is no application for setting aside or suspension of the award.
I have
Therefore,
time
all
for
the
that.
more. If he doesn't file, all the more. Even if he had filed.
Yes,
Yes, number two, maybe answer. There is, the relevant date is 3rd of October, which is day after tomorrow, for payment.
My lords,
for payment.
both parties
1
went
minute,
for
sir,
correction.
please.
The correction of the award was done.
3rd
26th
October is the
August.
relevant date because the second correction is a ministerial inconsequential correction. Its time runs from 5th of July. This is misleading to pay. 5th July, he gets till 3rd October to pay. Now, today, let's come to the practical part.
My share value is depleting.
Today, if I don't do the strategic sale by 5th January, under the clause of the agreement, my right lapses. So, what does he ask in 12.3? What is asked in 12.3? Justice of the case is what? Disclose information. He doesn't want me to disclose to me information on 12.3, which is all that I'm concerned about today before my lords, so that my right to sell before 5th January lapses. There is a direct clause, and that's the game he's playing. Now I ask myself a question. What is invasive about my learned friend in which I am 50% shareholder? Well, just note this. Me and the investors are 50.1% shareholders. What prevents him from disclosing except a very clever game by filing a non-maintainable appeal and keeping it dragging and saying you have a negative injunction, but I'll not disclose. Negative injunction is against his selling the shares to third parties. I have to find, well, the clause is foreign agreement lordship knows international arbitration clause is very clear, clause 19. If you don't do by 2016 cutoff date, I get an exit. Why can't he disclose?
My lords, the order is
Why can't he disclose?
for facilitation and implementation of the sale, and 17th October the case is coming up.
An affirmative order. Disclose. That's what? I'm sorry, my apology.
Chinese 12.3.
Sure, clear.
Set aside the. So we can
We will do
the tail. Well, one second.
Just 1 second.
Twist in the tail.
Sorry. What we will do is this. We'll issue notice in this appeal. We'll stay the operation of the. We'll stay further proceedings before the division bench in the appeal. Prima facie holding that it may not be maintainable. Now, he must have a bite at the cherry somewhere to challenge the conditions which have been imposed by the single judge. We'll leave open his remedy to move this court under 136, in which case we will consider the legality of the directions which have been issued by the single judge, because he has a case that, look, the award is not become enforceable today.
Absolutely.
Because
One-
that has
one
3 months
addition.
to.
I understand.
Let him file a SLT.
No,
with us
one
to the
addition.
judge.
I'll do that.
Please,
But in the
I-
meantime, my
please.
lords, let them not take action because
No,
the
no,
order
no, no.
passed
Stay against
is
me,
to
my
facilitate sale.
Stay
So
against me, my
facilitate-
Sundaram, Mr. Sundaram, you file an appeal which is not maintainable.
My lords, it was maintainable for one reason. I hadn't come to that.
Can I say one twist in the tail?
But,
Because
my
your lordship should.
Dr. Singhvi, I'm being addressed. Allow me to answer, my lordship.
12.3, which is only disclosure, is directed at the company R1. The company R1 doesn't file an appeal. In his first appeal by Mr. Sundaram, it doesn't challenge 12.3. 12.3 is non-prejudicial, non-invasive. It asks for disclosure of information.
He never challenged the 12.3 direction.
I'm sorry, my lord.
Actually hurt me because he knows my
Did challenge it.
January. Why should
My
I
lord,
lordship hear?
my lord, my learned friend is wrong on
We
fact.
will only clarify that our having stayed the judgment of the division bench will not prevent recourse to 136 of the Constitution against the original order of the single judge.
My lords, can I make one more request?
Nothing more, my lord. Single should operate then. Then I have to take my. I want information.
My lords, I have one.
Just say issue notice.
Yes.
My lords, can I just say one more submission, please?
Agarwal.
There is one important.
Please don't give him any Mala's words because that will
My
be
lords,
the High Court.
Or Mr. Sundaram, we'll give you another option. You withdraw your letters patent appeal and come here.
my lords, I'm saying, just give me 1 second. I want no more time. My lords, the award was, if 3 months after the award, it is not paid, then direction 3, the direction to sell takes over.
That's
That 3 months has not even expired.
Made the point. But therefore you withdraw. We'll give you one more option. You withdraw your letters patent appeal. I mean, not the letters patent appeal, the commercial appeal. And come here directly against the single judge's order. We'll see. We'll test the validity of the single judge's order.
Nothing else from my lordship.
Yeah.
My lords, the earlier order may be better because I'll only say this for one reason. Because I can't do that. My colleague cannot do that without his instructions. That's why, your lord.
But just keep this in mind.
But my lords, in the meantime, I only make one request. They say execute sale deeds. The order says execute sale deeds. That should not be done.
Lancashire Council, waive service. Full stop. Next. Prima facie, the appeal before the division bench would appear to be barred by the provisions of Section 50 of the Arbitration and Conciliation Act 1996 as interpreted in one, Andhra Export Corporation and another versus OCI Corporation, 2018-14 SEC 715, semicolon, and bracket 2, Tuesday Lawson Limited versus Jindal Exports Limited, 2011, 8 SEC 333. Full stop. Next, the proceedings before the division bench. The proceedings before the division bench of the High Court of Madras, before the Madras High Court, in so and so appeal numbers lelo, shall accordingly remain stayed. Full stop. We also stay the, in consequence, the operation of the impugned order of the division bench shall remain stayed. Next, this will be without prejudice to the liberty available to the respondents.
Lordship will give me liberty, Mother.
Yeah,
Not liberty.
without prejudice the liberty available to the respondents to challenge the order of the single judge in independent proceedings under Article 136 of the
My lords, I have one request. My learned friend says it's only to get information. The order reads as though they can execute sale deeds. My lord, let sale deeds not be executed.
That we file an
friendly option.
File an SLP.
The lordship is giving a lawyer friendly option.
Moving to Sundaram appeared in law.
In Lawson.
Yes, I
This
noticed
is
that.
exactly what you had argued, and it has been negative.
No, well, that stock
I was hoping I would get it reconsidered by 3 of my lords. Lawson was 2 of yours. I was hoping to have it reconsidered.
applies only to
Actually, Lawson appears because there's a clear distinction in the language of the 2 sections.
37.
I saw that.
And there is a
But Lawson
point there.
noticed it. You know, they noticed the difference and
I was hoping to have it reconsidered by 3 of your lordships, but anyway, my lord, that is not. Can I make?
International arbitration view, we should be very careful.
My lords, I would try.
Some certainty in these matters.
My lords, I'm only worried, my lords, when I have that time to file the setting aside. Meantime, they implement the award and in fact enforce the award. I will do one thing, my lords. I'll have an SLP filed tomorrow itself and then seek liberty from your lordships. There's nothing.
applies only to your lordship, not to us.
This is my third petition before your lordships. I have since retired. Your lordships will not protected my post. Your lordships appointed an SIT. The High Court says, my lord, I have never heard this, that the SIT will not file, my lord, the report under 173 before the court, but will file it before us. My lord, the manner in which, my lord, this, sorry. But this order is pronounced on Monday morning. It doesn't come in the list. The learned judge will not hand it over.
Notice. I mean, if we issue notice, returnable after 4 weeks. Pending further orders, the impugn judgment and order of the Division Bench of the High Court of Himachal Pradesh, dated 23 September 2024, shall remain stayed.
Grateful.
Discussing in hours.
कोई नहीं है.
Discuss the default order. We just get it. Get. So we'll just take Mr. Vikaram, we'll just take a break for 2 minutes and come back. But we'll start the parthead. Parthead will be good till lunch. Though both sides are there. So we'll discharge the rest of the board till 2 o'clock. Between the two of you, finish by lunch. We'll just come back in 2 minutes, just a little break. That's all.
May I please? Look, I just recapitulate in 5 minutes. Out of a lot, there are four broad issues. 3 have been covered so far, and we're going to deal the fourth today. The first issue, my lord, is
Order of this court not complied.
1.
In violation of this court's order.
1.
There are 107 legally incorrect. Tribunal is aware of the resolution plan. Still, it adjusted PBG first and security later. 150 first tranche, 475 non-payment of airport dues upfront, 289 workman dues, 914 aggregate plus 250 mortgage, 101,164. That's the figure. Now you proceed.
Obligation, Lordship. I don't want to put it beyond this. If you oblige. Yes. Lord,
And we left you on the last day with conditions precedent.
Yes.
And you are referred to clause 7.6 of the resolution plan at page 286.
Correct. We stopped there. That's the last portion which we need to deal. Broadly, my lords have recollected already. One is, my lord, the adjustment of PBG coupled with the mortgage. How it went wrong. Second, my lord, is the airport dues. Third is the workman's compensation. Now, fourth, my lord, is the condition precedence, which we, your lordship, have to deal with. But condition precedent has 2 parts. There are 3 issues in condition precedence, but essentially broadly in 2 parts. Your lordship will first have to freeze the issue relating to the effective date of implementation of the resolution plan. That's critical when we deal with condition precedence. Because according to them, we have been dragging the whole issue on condition precedence and we never allowed them to comply. Well, the documents will reveal on its own what has happened. So for that, to enforce, my lord, that they are wrong, we will show first to your lordship what is the effective date. That's one issue, which your lordship may come to in our main compilation, PDF page 287. Paper book, the SLP book.
The main diary.
The civil appeals.
Sanjay.
So, Lord, PDF page 287.
7.6?
0.2.
$282.
Well, Lord,
280.
287. Internal 261. Internal 261.
PDF 282.
I'll go with printed page then. Should be 287. 287, yes.
Additional documents?
No, my lord. Yes, sir. A civil appeal.
Oh, the main civil appeal.
Main civil appeal.
Fulfillment of conditions precedent.
Yes. 7.6.2. Yes. That day also we referred only to the civil appeal main book.
Yes.
The lordship sees this clause 7.6.2, fulfillment of conditions precedent. The date of fulfillment of all conditions precedents as stated in clause 7.6.1 above shall be the effective date for the purposes of this resolution plan. This was originally so broadly worded. Now, my lords saw it, 7.6.2. My lords may see 7.6.1, the condition precedence, which is now what we're going to malord. 3 clauses, A, C, and D. A, my lord, is validation of air operation permit of the corporate debtor by DGCA and MOCA. The AOP of the corporate debtor shall have been validated by the DGCA, the MOCA, and any other relevant government authority, and grant of all other mandatory approvals to the corporate debtor to enable it to recommence flying operations, including commercial or cargo operations and related on-ground services. So, my lord, an AOP is mandatory precondition. And they got an AOP, my lord, in May 2022, 20th May 2022, valid for a period of 1 year. The NCLAT records that fact. We'll show that in a minute. So their AOP was valid just for an year, 25-2022 to 25-2023. Then lots may come to clause C. Slot allotment approval, clause C. The DGCA and MOCA shall have approved the reinstatement of all the suspended slots, including the bilateral rights and the traffic rights back to Jet Airways by corporate debtor. The slots along with related bilateral rights and traffic rights can be allotted to the corporate debtor gradually as per its business plan with immediate slot allotment approval along with the related bilateral rights and traffic rights for sectors on which Jet 2.0 proposed to recommence operations after the effective date. But this they said, we had 48 slots with us, but 48 slots, we will show that letter to your lordships and the finding. Both the NCLT and the NCLAT records the finding. 48 slots is subject to clearance and payment of airport dues. Not a rupee was paid. So it's not a blanket approval of slots. So we'll not C. Now please come to D. International traffic rights clearance. The corporate debtor shall have received the international traffic rights clearance in compliance with the applicable laws. The applicable laws mandate they must have minimum of 20 aircrafts. It's conceded in the order, we'll show to your lordships. That is why we are saying all the three, my lord, there's an infraction. All the three completely and in total contravention of what is contemplated in the resolution plan. Now, Lord, before we take these three violations, we will freeze the issue on effective date, because if your lordship sees, after reading these three clauses, please come back to 7.6.21 last time. It looks very broad. The date of fulfillment of all condition precedents as stated in 7.6.1 above shall be the effective date for the purposes of this resolution. Therefore, till such time they comply with the conditions, the effective date will keep on postponing, not it look like that. And that was also their case. Look here, you are saying I have not complied with the condition precedent. When you say that, when credit lenders say you have not complied with the condition precedents, very fair, then effective date will not come into force. But this is their case. Unfortunately, my lord, to them, fortunately for us, this stands modified by the NCLT through three orders, which your lordship will now see. The first approval order, my lord, is 22/6/2021, and it starts at PDF page 22/6/2021 was the plan approval order. But it starts PDF page, it starts at 342, but your lordships can directly come to PDF page 394, para 33. So that's the passage.
Para 33.
33. Can I read that, please? During the hearing, the uncertainty of the time frame for implementation of the resolution plan was discussed. It is stated by the SRA in clause 7.6.2 of the resolution plan that the effective date would mean the date of fulfillment of all the condition precedents as stated in 7.6.1 thereof. The SRA at clause number 7.6.4 has gone on to add that consortium would make all endeavor to ensure all compliances are done for the fulfillment of the condition precedents within a period of 90 days. In the unlikely event that the condition precedents are not complied within this period, SRA would require a maximum of 180 days more to fulfill the conditions. So the final is 270 days. No problem. Failing which, the resolution plan would stand automatically withdrawn without any further act, deed or thing. In view of such uncertainty in the effective date, the bench suggested that let the effective date be the 90th day from the approved date, which is 22/6/2021. The SRA as well as the applicant had agreed to the suggestion. This, in our opinion, is not in the nature of substitution or addition of the decision, commercial or otherwise, of the COC. The suggestion is made only to give finality and certainty to the effective date, which the SRA has otherwise committed in the resolution plan to endeavour to do so. It could accordingly be ordered so. Failing which, the SRA or corporate debtor would be at liberty to approach this authority to appropriate orders with regard to the extension of timeline as would be deemed proper. That would help prevent the SRA from frustration of automatic withdrawal referred to in clause 7.6.4 of the resolution plan. The three things are clear out of this. A, they accepted for a 90-day cap first and said we can extend it by another 180 days. So the maximum cap according to SRA can go up to 270 days. And the second point important is the order records. Failure to comply with the conditions precedent effective date will result in automatic withdrawal of the resolution plan. That's one of the findings in para 33. It's automatic. But we are struggling for 2 years with court battles. So para 33 says, failing which the resolution plan would stand automatically withdrawn without any further act, deed or thing. So please note the dates. A, 22/6/2021, NCLT passes the resolution plan, approves the resolution plan.
Just repeat it.
Sorry.
Just repeat it.
Yeah, 22/6/2021, NCLT approves the resolution plan, PDF page 342. So the 90-day window expires on 22/9/2021 in terms of para 33.
Expires on 90-day window expires on
22/9/2021, 22nd September 2021. Then, my lord, it gets extended. Your lordship will come to PDF page 402. They couldn't comply within 90 days and they were given a window of 180 days to apply. So they applied. So, my lord, the first extension came on 29/9/2021 at PDF page 402. Extending it to another 90 days. Which expired on 22/12/2021. So the first extension of 90 days, further extension of 90 days, it was done on 29/9/2021 and it expired on 22/12/2021. Again, not compliant. Then, my lord, the second extension happens. That your lordship will get it in the next page, PDF page 404. 21/2022. Yeah. (21/2022). Lord, it starts at 404. Please come to PDF page 407, last paragraph. Extended by 90 days from 22/12 to 22/3/2022. The order came to be passed in January, my lord. They extended it from 22nd December because it expired on that day. 3 months. 22nd December to 22nd March 2022, which your lordship will get it at 407. This application was earlier heard on 22/12/2021, and keeping in view the terms and conditions of the resolution plan approved, the following order is passed. The effective date is extended till 22/3/2022. The earlier up to 22/12 in terms of our order dated. This is within the terms and conditions of the approved plan, wherein it was stated that the effective date will be maximum 270 days after the approved resolution plan is on 22. So, my lord, the maximum extension now stands granted 22/3/2022. Again, not compliant. And therefore, a last extension is granted. The last extension, my lord, is 413 PDF on 11/4/2022. Yes. 11/4/2022, para 20 at, my lord, PDF page 424. 424, paragraph 20, my lord. Short paragraph. In that view of the matter, we find that if relief as sought for is refused, it will cause hurdle and revival of the corporate debtor, which cannot be the spirit of the code. If no exclusion is granted, it will also amount to automatic withdrawal of the resolution plan, and the corporate debtor shall be posted into liquidation, which is neither the intention of the code nor of the plan approval order. Hence, application is liable to be allowed excluding period of 65 days and thus extending the effective date on 25/5/2022. Now, two things are.
The 270th day expired on 22nd March. So now, further extension by 2 months.
By saying we will exclude the period of consideration of these applications, which was 65 days in number. Now, because two applications were filed, my lord, order came to be passed little later. So they factored those 65 days, excluded it. To say that it is still within the range, but not, again, what is important in para 20 is two things, my lord. One, they don't go beyond 270 days. They backward 65 days and say and arrive at 25/5. So it can't go beyond that, and it has not gone beyond that. And say that if you are non-compliant, withdrawal is automatic and liquidation is the only option. It says this order becomes final. Nobody has challenged this order. Para 20 very clearly says it will also amount to automatic withdrawal of the resolution plan, and the corporate debtor shall be posted into liquidation if they don't comply with it.
Now, this 65 days which was excluded was on account of what?
2-3 applications they filed, my lord. One in September, one in December.
Oh,
and
that's why they...
Because the disposal date, they excluded it.
Oh, I see.
Okay. We have also not challenged that.
Between the filing of the application and the date of the actual order.
For example, my lord, in December 22nd, they filed it. The order came to be passed in January 20th. Similarly, they filed it in 22nd March. Order came to be passed on 11/4. So they factored that and excluded this 65. And we agree. We have not disputed it.
So the last extension expires on 20, and that's the end of the 270-day piece.
Not beyond that. Nobody can now do anything. And my lord, it very clearly says if you don't comply with the consequences, my lord, it is reiterated in the first order. I'll just repeat one last time, my lord. The first order is 22/6/2021 at PDF page para 33. It says so. That is, my lord, 394. And again, it reiterates in the last extension order, para 20 at 424.
Was it a substate? It's a Jamshed's exam.
This was not extended except on two occasions. NCLAT, when affidavit saying that we will waive all these extended it up to 1st August 2023. I'll give the date of the order. 31st August 2023. It extended it up to 30/9/2023. What is this order?
After you 39.
30th September.
Yeah, two orders. 25/5/2023 order of NCLAT.
25/5/23.
23 by para 8. Not PDF page 847.
You said 25th May 23.
Yes, 26th May.
First order.
25th May, no?
No,
just give us the date.
Yes. 25th May or 25th May. 25th.
Extended till
31st August 2023.
Where is that order? Page?
I think I stand corrected. 26th May. Please change it.
All right.
26th May. Sorry. Last order is 26th May of NCLT, NCLAT. PDF page 847, paragraph 8. Yes.
And then?
And then on 25th August, 28th August 2023, PDF page. They extended it to 31st September 2023.
Extension till?
31/9/2023.
39.
30/9/2023. And your lordships, my lord, on 18th January 2024, gave another 2 weeks, which expired on 31st January 2024.
Just repeat it.
Sorry. My lord, one is this 26th May.
That we have not.
Second is 28th August, extend up to 30th. Third is your lordship's order.
8 January.
18th January.
2 weeks.
2 weeks.
On
31st. As far as the first time. So these three extensions were again, in spite of 270 and all, how much more accommodation can we think of? And the order keeps blaming us with great respect. It says that you are instrumental for all this. How are we instrumental? We did not stop them from paying. So they have not. Now, please see these infractions of the three condition precedents squarely. Please come to the air operation certificate. My lords will see. But the NCLT order on this, my lord, PDF page 568. The NCLT order is 13/1/2023. That's the order, my lord, which says all the conditions precedent stands fulfilled. NCLT itself. That is why we appeal.
NCLT order dated
13/1/2023. PDF page 568. Lord, what we have done, we have prepared a small list of dates also. We'll give it finally. All this, whatever we have referred, we have put it in a neat, I will just place it to your lordship.
Just PDF page?
PDF page 568. We'll find that. Yeah, we have filed it also. It's in your law. We have checked it up. It has reached. We have served it on the other side. Just for a correlation, in case any page.
So you filed an appeal. SBI filed an appeal.
Which is, my lord, what finally culminated in this order of NCLAT on 12/3/2024. The impugned order, which is in your lordship's court for examination. This is the first order.
NCLAT dated
12/3/2024. So, my lord, in this, the findings, my lord, start.
Upheld the NCLT order.
Upheld in total. My lord, findings start at 692 PDF. It's a very long order. It starts, my lord, at 568. Please come straight to, my lord, para 122, 692.
Para 122.
I'm reading the NCLT order dated 13/1/2023.
Oh.
I'm reading now the NCLT order. I'll show both the findings.
1 second. We have to.
Yes. That NCLT order finding starts, my lord, at 568 PDF.
At 692.
At 692. My lord is right. At 692. Just one paragraph. Para 122 relates to the first condition precedent, air operation permit. My lord has it.
122.
122 is, my lord, one short para, that's all. We note that Honorable Enclad in his order dated 21/10/2022 in an appeal by so and so, and after hearing the parties and considering the objections on completion of condition precedence, has already held that SRA has complied all necessary CPs to the satisfaction of the MC. It would not be out of place to reiterate that the MC lenders took an IA 4771 of 2022 seeking clarification of the in order, observing completion of all necessary CPs to the satisfaction of the MC, which was rejected by order dated 2012-2022. As such, the findings of the Honorable Enclad in the order dated 2012 is reinforced by the said authority. However, having considered the rival submissions and on perusal of record with satisfactory compliance of condition precedent, it is noted that there is no dispute so far as satisfactory compliance of condition precedents 1 and 5 as per approved plan. One is validation of air operation certificate by Director General of Civil Aviation and Ministry of Civil Aviation of so and so. Yes, this judgment was, this order was passed on 13/1/2023, at which point of time they had a valid AOC because they applied it on 20th May 2022 and they were issued it for 1 year. Both record. So when this order came to be passed, they had a valid OAC till 20th May 2023 and not beyond that. So what they did, please come to this PDF page 728.
Valid AOP till 20th May 23.
23, 1 year.
From 20th May 22 to 20th May 23.
My lord is right. So what they did, please come to PDF page 728. They applied for a fresh AOC.
July 2020.
My lord is right. So they applied it on 16th May 2023 because it expires on 20th May. Please, I'll just a very short letter, I'll read it. See the limited extension with lot of conditions. Lot 728, my lord has it? Yes. Married? Yes.
Yes.
Reference invited to Jet Airways letter dated 16/5/2023, followed by email dated 12/6/2023 and discussions with so and so on 14/7 and 27/7. In view of the fact that Jet Airways is still undergoing CIRP under the IBC, NCLT and NCLAT, having the jurisdiction respect of the insolvency of the company, have granted extensions for exclusions at the time for the implementation of the approved resolution plan up to 3/9/2023. The AOC so and so in respect of Jet Airways shall be considered as valid until 3/9/2023, subject to the following conditions. A. This extension shall be applicable only for the limited purpose of completing the ongoing CIRP. 2. Jet Airways shall be required to undergo a recertification in accordance with the procedure contained in CAP 3100 as applicable for issuance of an AOC and demonstrate compliance of all applicable regulatory requirements afresh before commencement of the flight operation. 3. Fee as applicable for issuance of AOC shall be payable for such recertification. 4. Jet Airways shall submit a firm action plan for revival of operations after the company is taken over by the SRA in accordance with the NCLT approved resolution plan. This issues with approval of the Director General. So, my lord, the whole extension is limited only up to 3/9. But we are not a cause of it. Which subject to, if you want to renew post 3/9, you'll have to comply with all these 4 conditions. But please come to now this PDF page, which your lordship will get it, page 842 in the same compilation. But this is the letter DGCA issues to us, to the lenders, on 26th December 2023. Please, my lord, 816. Reference may please be made to your letter dated so and so on the above subject. This is addressed to us. In this regard, it is to intimate that this office has not given any further extension to Jet Airways, which was valid till 3rd September 2023. So, my lord, after 3rd September, they don't have an AOC till date. And now see the NCLAT order. So, without an AOC, my lord, how will an airline fly? When will they revive? That is a condition precedent. Now, my lord, please come to the NCLAT order. NCLAT order, my lord, this portion is, my lord, 126. Page 126. Printed page 100. It starts from page 1, the impugned order. PDF page 126, paragraph 116. Just one paragraph. Can I read? Yes. We have noted that air operation certificate was granted to the corporate debtor on 25/2020. My lords may see that. For a period of 1 year, which they got extended it to 21 and they got extended to 23. Every year they extended it by 1 year. The corporate debtor, as per the air operation certificate, could very well have commenced the operation after completing the other conditions in the plan. However, the SRA could not commence the operation due to the stand taken by the lenders that SRA had not complied the condition precedent. And in spite of the order passed by the adjudicating authority on 13/1/2023, declaring that SRA has completed the condition precedents, no steps were taken by the lenders to proceed to the implementation of the plan. Rather, lenders have filed appeals in the tribunal challenging the order. Air operation certificate was also extended. An extended period also came to an end by September 23 due to the litigations pending between the parties as noted. We thus are of the view that SRA has to make appropriate application for reissue of air operation certificate as were earlier reissued by the Government of India. Officer of the Director General of Civil Aviation. The SRA to immediately make an appropriate application for reissue of air operation certificate and complete all necessary formalities so that before the closing date, air operation certificate may be reissued. The Government of India, Officer of Director of Civil Aviation, Minister of Civil Aviation may take necessary steps regarding the air operation certificates in accordance with law. There being already sufficient delay, having caused in the implementation resolution plan, an air operation certificate issued could not be used by SRA due to the roadblocks created in the implementation resolution plan. We are of the view that Director General and Ministry of Civil shall take steps expeditiously. In event AOC is not received before closing date, the SRA shall take all steps to receive it within 90 days after the closing date. Over.
Basically, the court had put the blame at your doors. The lenders didn't cooperate, that they took recourse to litigation, that there were roadblocks by you.
And extended in normally the tragedy is it extended 90 days. 90 days is over. That is over. This order came to be passed on 12/3/2024. 90 days expired on 12/6/2024. No air operation certificate. How more leniency and indulgence? How much more? So this takes care of the first infraction A. Not an airline can't say, I had an air operation on the date of approval of the plan. I don't have to show air operation approval after that. But that's no ground. At every point of time, you should have an air AOC to fly. So, my lord, please see. Then, my lord, the next is subclause C of 7.6.2 slot allotment. And, my lord, please see the NCLT order at, my lord, PDF page 694, paragraph 124. PDF 694. Paragraph 124. That's a very short paragraph. As regards slot allotment approval, it is noted that plan approval order of the tribunal dated 22nd June 2021 stipulates that no historic slots will be granted to corporate debtor SRA. Admittedly, there is no challenge to this order, thereby accepting the fact that old slots cannot be reinstated. Accordingly, this CP needs to be read with the plan approval order, where corporate debtors shall be provided with such slots for which it applies. There is no dispute that slots for which SRA apply were granted to them by the concerned competent authority, including the slots in Delhi and Mumbai, on settling the old dues. And as such, it cannot be considered as a non-allotment of slot, as SRA has received the slots it requested for in compliance with the plan approval order. The SRA cannot get all previous slots, as this condition needs to be read with the approval order of the tribunal. In view of the matter, the above CPs is also found to be satisfactory compliant without paying.
Venkataraman, I hope you'll complete.
I'll complete. No, last two will. I'll complete. 100% I'm completing by lunch will. Not a minute more. So, my lord, the second infraction, my lord, please see, it says slots are allotted, and it also says in the same breath the order of NCLT, subject to payment of the airport dues. Not a rupee paid. On settling the old dues. That's the condition. And why is this condition imposed, my lord? Please see PDF page 81 in the additional document. Additional document. Page 81. This additional document. This is the only document I want to show, my lord. PDF page 81. Please see, this is one of the airport slot allotment by mail.
Page?
The additional document, printed page 76, PDF page 81.
Annexure A32?
A32, my lord is right. Annexure A32.
Okay,
And my lord, it says, Lord, Mile sends this to them. Your email on the subject matter refers, we are happy to consider your request for slots and parking bay during the ongoing summer schedule. The same is subject to closure of the ongoing discussions pertaining to settlement of outstanding dues of Jet Airways towards Mile. We are equally looking forward.
Email is from whom? From
Mile,
Gilbert John.
Mumbai International Airport Authority.
Oh, I see. Gilbert is from Mile.
MIL. That is why, my lord, NCLT in PDF 694 para 124 records, slots are granted subject to settlement of old dues. So, my lord, to say that already they have got the slots, my lord, is wrong. You would get it if you pay. Pay and take it. My lord, the same thing is repeated by the NCLAT. My lord, at PDF page 75 of the appeal, of the main appeal, civil appeal, I'll read only paragraphs 48 to 50 and 55, but I'll read only two paragraphs. It starts at 48, at 75. My lords may go to paragraph 50. SRA, as per business plan, was initially required to secure 46 slots for the first aircraft carrier. However, up to the effective date, SRA has secured more than 48 slots for recommencement of corporate debtors operation. Details of slots secured by the corporate debtor already are noted at page 987 volume 4 of the appeal, which indicate 48 slots have been acquired by SRA for recommencement of corporate debtor operation. When the necessary slots as per business plan were acquired by SRA, we failed to see that on what basis appellant is contending that condition precedent as under so and so was not fulfilled. The adjudicating authority in the impugned order, after considering all relevant facts and circumstances and considering the submission of the party, has returned its finding in para 124. The slots for which SRA complied were granted to them by the concerned competent authority, including the slots in Delhi and Mumbai, which is subject to payment. That's completely left out. This is reiterated in paragraph 55. One 3-line paragraph at PDF page 80. With regard to the submission of the appellants, that old dues of airport charges have not been settled. The adjudicating authority has rightly observed that settling of old dues cannot be considered as non-allotment of slots. We thus fully concur with the finding of the adjudicating authority that condition precedent C has been fulfilled. Great respect. So this goes. What remains last, much more hurting, international traffic rights, which is condition D of 7.6.2 at 287. My lord, please see the NCLT order and enclator. That's all. NCLT order, my lord, is at 695, paragraph 125.
International traffic right clearance.
My lord, paragraph 120. Can I read that? On perusal of the plan approval order dated 22nd June, it is found that no blanket approval can be granted upfront to the SRA, as it has to approach the concerned authorities for grant of such approval as per applicable laws. As already stated above, the plan approval order has reached its finality, thus accepting the fact that all approval issued upfront cannot be reinstated. Accordingly, this condition precedent needs to be read with plan approval order. Even otherwise, there is no dispute under the plan approval that SRA has to recommence with operation of 6 flights. The international traffic right clearance is required to be obtained in compliance with applicable laws, which stipulate that minimum 20 aircrafts are required to be deployed before applying for such clearance. In view of this, we find that this condition cannot be satisfied upfront and needs to be satisfied in compliance with applicable laws after SRA has 20 aircrafts in operation, which can be achieved only once operation is recommenced successfully. Accordingly, this condition can only be fulfilled by SRA when applicant recommences business and not prior to. Now, how does condition precedent become condition subsequent? This is nothing but completely swapping the plan. A condition precedent, mandatory condition precedent to be fulfilled before the effective date, becomes through a judicial order a condition subsequent. And this is upheld by the NCLAT in toto. Paragraph 56, my lord, PDF page 80. It starts at 56. Clause is extracted. Letters are all extracted. Please come to 58. Para 58. Same thing. Full repetition. The adjudicating authority, middle of the portion, my lord, the adjudicating authority has not committed any error in holding that the condition precedent cannot be satisfied upfront and need to be satisfied in compliance with applicable law. After SRA has 20 aircrafts in operation, it can only be granted once our operation is recommenced successfully. We are thus does not come in the way of implementation resolution plan and commencement. When you agree for a resolution plan, you know we didn't do anything behind your back. If plans are going to be changed through judicial order, which my lord, this court has said no. How many times? So my lord, third is gone. Therefore, my lord, the fourth infraction, one is my lord, bank guarantee plus mortgage. Second is my lord, airport dues. Third is my lord, workman's compensation. And fourth, my lord, the entire set of condition precedents A, C, and D. But the B and E.
Just repeated bank guarantee.
Bank guarantee coupled with, my lord, non-furnishing of mortgage security.
1 second.
Yeah, 150 crores plus 250 crores. First tranche payment of 150 crores. Out of 350, only 200 has been paid.
Airport dues.
Airport dues, 475.
Workman compensation.
Workman compensation, 292. Only 12 crore. We showed it to your lordship. The NCLAT says if you pay 12 crores is sufficient. But what is interesting, that finding runs counter to your lordship's judgment, upholding the NCLAT order, and runs counter to the very same bench order.
Third is workman's compensation.
Yes.
Then?
And fourth is, my lord, violation of condition precedence. But we want to put a question to ourselves because it says everywhere, How are we responsible for this? In what way are we responsible?
Amount remains 1,165
crores. Upfront payment. My lord, please note the time. My lord, these dates are, I'll just show one last date. My lord, this resolution plan is a 5-year plan. My lord, please come to page 288 PDF.
Mr. Venkataraman, you should be taking classes for the members of the bar on using PDF pages.
Certainly.
Most lawyers have a problem with saying what is a PDF page. It's all uploaded, sent on SMSs to lawyers. Nobody wants to use the PDF pages. It's otherwise so streamlined. We are all in such a large volume of the record. We're all on one page.
We are doing one arbitration, 42 volumes, my lord. You can imagine. All we are done. 11 days of hearing over. Completed. 3 hours every day evening, 4:30 to 7:30. Over. It's one. I did not carry anything else other than 42 volumes. Yes. Lord, please note your lordships. The CIRP started on 26/2019. And plan was approved on 22/6/2021. And Lord 288 says, please come to serial number 28 at 263 or 289. Redemption of the NCDs and release of any charge. Z is not the starting point, effective date. Effective date plus 5 years. Now, we have crossed 3 full years. We are struggling, my lord, to collect the first tranche payment. But what more can we now wait for? We just really don't understand. And the my lord, NCLAT is putting it on us, on a lender. Lord, the lordship has to, my lord, please set the law. Very important. That these are all public monies. So out of 5 years, we have crossed the midway and we are struggling for the first tranche payment. The last 2 information, with that I close it. But please see what is important, my lord. We have given one set today. Additional set. Oh yeah, it's there. Yeah. Additional set page. Oh, it's there already. Yeah. Additional set page 10. My lord. Application on behalf of 10 of additional. Just now your lordship saw that. No, that is different. No, that is 8. Yes, correct.
Yes, yes. Today at compilation of documents 30th September.
Correct.
Not today.
No, not today, Mullah. That is that I'm going to show a little later. Court master has got it.
The additional diary page 10.
Page 10. Page 10. Yes.
Rise with investor Florian Fish in Australia.
But he is one of the investor. He is the SRA. He is one of the SRA. Murali Lal Jain and Florence Fish. These are the 2 SRA. Your lordship will see the plan.
This is what some news article or what?
Yes, news item. But I'm not saying banking on that. Only to say money laundering proceedings in 3 countries.
Against whom?
Against this SRA. And therefore, what we did, my lord, we applied to the civil aviation to know whether Home Ministry clearance has been obtained. Because there is a requirement. If you run a money laundering proceedings, nobody will give you security clearance. In 3 countries, my lord, Austria, Liechtenstein, and Switzerland, they say that they have settled in the juries, but never. My lord, we are not trying to say much on it. All that we are saying is, based on this, today, if your lordship comes to the set which we have filed now, by email we are given a set of 20 pages filed today, 1/10/2024. It's, my lord, 39/2024. Yesterday evening.
Compilation of documents 39/24.
20 pages. My lord, please see at
yes, 20 pages.
Yes, page 1. Officer of the Director General of Civil Aviation. Yes, yes. Only 2 documents, my lord, with that time.
PDF?
As promised before 1. Lord, yes. PDF page. Now, my lord, it starts to PDF page 2, lords may come. This is a
compilation.
compilation.
20 page.
Lord, yes, it's a Lord, it's a dossier issued by my lord the DC, the Director General of Civil Aviation. Requirements for undertaking an aerial work. If you want to run an airline, what are the requirements? Please come to my lord. PDF page 4. Security clearance is a mandatory condition. Clause 6, security clearance. The applicant, in case of a company, its board of directors shall be required to be security cleared from the Ministry of Home Affairs. The positions of the Chief Executive Officer, Chief Financial Officer, Chief Operating Officer, and any other similar designations in the case of a company, and exercising management control if held by foreign nationals, would also require security clearance from MHA. Ministry of Home Affairs is the competent authority for grant of security clearance. The applicant by a company and its board of directors should be required to obtain security clearance from the Ministry of Home Affairs.
Seen it, yeah,
Yes. And last, my lord, last document in the page 20, what DGCA has confirmed to us on 9th July 2024 that the SRA has not obtained security clearance till date. Yes, 20. Yes. So, Lord, please come to page 20. I am direct, Lord, this is issued by the DGCA. I am direct to refer to so and so on the subject cited above and to inform security clearance has not been conveyed in respect of so and so, and the details for information furnished by Jet Airways in this regard are under assessment. Lord, please see dated 9th July 2024, as latest as 9th July. You don't have a security. Well, why we are referring to these two is PDF page 209 of the main appeal, clause 2.1.4 of the resolution plan. 209 of the main appeal. PDF 209.
Clause
2.1.4. The resolution applicant is defined to mean a consortium of. Yes. Serial number 2 is this gentleman, who has no security clearance in India as on date. So, my lord, may I therefore finally play, my lord? These are our final prayers. My lord, please come to PDF page 3. I'll show the class, my lord. My lord, 3.13.7, Lord, at RFR, page 189 of the same compilation. Yes, we'll show that. Yeah, we'll do that. We'll do that. Yes. Lord, 3.13.9 at PDF page 189. Sorry, 3.13.7. Subclause C. Lord, SBI, in its capacity as an agent of the COC, shall have the right to invoke the performance security on behalf of the COC.
3.13.7 has no C.
No, it's just.
Sorry, 3. I'm sorry, 3.
Roman 3, small.
But main clause says I can do following conditions without any reference to the resolution applicant. I can enforce it. When failure of the successful resolution applicant to implement the approved resolution plan to the satisfaction of the COC and in accordance with the terms of the approved resolution plan. It's not enforceable. Please see this final chart, my lord. With that, I wind up. Give it. This is what we have to bear. Lord, besides this performance guarantee, Lord, we have not, your lordships, Lord, we are litigating, no doubt, but we are litigating for a genuine reason all throughout. And my lord, as confirmed by the SRA, this is the expenditure which is not running into the books. RP, as per the resolution professional. The 3 airport dues today stand at 1,120 crores. It's in lakhs, we converted it. This was given in July, but it's okay. Whatever is the date. 1,124 crores is the airport dues. 506 crores is the CIRP costs. And the total is 1,631 crores because of their default. Consistent. What should have happened within 180 days, within 270 days? Lord, please tell us, Lord, we have been canvassing all this. At every point of time, we are succeeding before this court. Labor plan is approved. The tranche payment is approved by your lordships. Now, third innings, we are coming here to say that all the 4 findings of the NCLAT is wrong. And Lord, your lordship may kindly invoke your Article 142 power and send this to liquidation, so that whatever is remaining, we'll at least salvage it. There's no choice for us. Is all that we respectfully pray in your lordships. Extremely obliged, Lord, for this intervention.
If we don't invoke the power under 142, then where does that leave us?
33.3, my lord, we have to go to NCLT and the whole process becomes an
Go to NCLT under
again, so many years. But they are all this, my lord, somebody wanted to buy the aircraft, they are running away because it's uncertain. It's all becoming metal scrap.
We'll hear the answer. Yes.
Please, Your Lordship. Lord,
Can I just be given a few minutes, my lord? In my appeal, it's an independent appeal.
He's argued it now.
There's one point which was not taken care of, so therefore I thought I should address.
What was that?
My lord, there's an observation in the order or in the impugn order as to why they are permitting only 12 crore of provident fund to be paid upfront, and they say that the rest of the amount is to be paid later on. So I wanted to only
shows that.
So my lord, if my lord will kindly come to page number 129.
PDF.
Please, ma'am.
In the main diary.
In
Give us pages from 7 now.
Then my lord, I'll
use one paper book.
I can do that, my lord.
Just tell us. Okay. (123) is that clause of what?
Of the impugned order.
Of the impugned order.
You are referring to workmen and employees' dues. That's internal page 97. Okay.
Yes, ma'am.
Where is the order beginning? Yes, workmen and.
So, my lord, please see that they have given an extract of the earlier order of 21st of October 2022 at the bottom of this page, para 112, and the extract starts on the next page. My lord, I'm reading from the extract. The appeal of workmen and employees being company appeal number so and so are partly allowed with the following directions. A. Successful resolution applicant is directed to make payment of unpaid provident fund to the workman till date of insolvency commencement after deducting the amount already paid towards the provident fund in the resolution plan to the workman. The workmen are also entitled for payment of their gratuity dues as on insolvency commencement date after adjusting any amount towards the gratuity paid under the resolution plan. It is made clear that entitlement of those employees and workmen who are demerged into AGSL shall not be there since demerger has not been treated as termination of their services. My lord, may I please then turn over the page to the last clause F. The chairman of the monitoring committee, erstwhile resolution professional, is directed to compute the payment to be made to workmen and employees within 1 month from today and communicate the same to the SRA to take steps for payment. Then what para 113 is the finding. When we look into the above directions, it is clear that the amount to be paid by SRA towards provident fund and gratuity was the amount to be paid after adjustment of the amount received under the plan. The above clearly indicates that the amount is to be received by the workmen and employees under the plan first, and thereafter the amount has to be paid as per the order dated 21st of October 2022 regarding full provident fund and gratuity. So, my lord, they are relying upon clause A and B, which give a sort of an adjustment that under the plan, because there were certain amounts towards provident fund and gratuity, so pay that first and thereafter pay the full gratuity. That's the way the National Company Law Appellate Tribunal has proceeded. Our submission is, my lord, that they have skipped the last clause F, which is the most vital clause here, which says that the resolution professional has to calculate the amounts to be given to the workmen within a period of 1 month, and thereafter the steps have to be taken by the SRA for payment. Number one, my lord. Number two, it was nobody's case that first I have to be paid under the resolution plan, and thereafter my full provident fund and gratuity has to be paid. In fact, the SRA itself filed application, and that application is also on record, where they said that I want 2 years moratorium for payment of the gratuity, and thereafter from the 3rd year onwards, I will start paying the gratuity of the workmen. 3rd year, I'll pay 1/3. 4th year, I'll pay another 1/3, and in the 5th year, I'll pay the last tranche of the 1/3. So they wanted it to be paid within a period of 5 years. Thereafter, on that application, they make us a party. And that's how we step in. Because unless you make the workmen, how will the workmen come to know what is happening? So they make us a party in that. We are heard in that application. Thereafter, they move another application. In that application, they say that unless you allow this payment to be given within a period of 5 years, I am not going to be compliant with section 32 subclause 2 subclause E of the code, and the plan will fail. That's what they say. And therefore allow me to withdraw the entire amount right now, whatever I've paid, and let me walk out. All those applications have actually been looked at, have not really been looked into by the NCLAT in this order, impugn order. They simply say that we are disposing of all the applications with the directions that we have given. So, my lord, our case is that if those applications were looked at, which they have filed, so my lord, for that, if I can request my lord to take my paper book, because I filed it in my paper book. In that application, their own application, the SRS application, where they pray that I want to make the payment within a period of 5 years. I just thought that I should show that, my lord, it's in my application, it's on page 791 of my appeal.
That we have seen it. Para 115 also you have seen.
So, my lord,
they say let the implementation of the resolution plan start, then the workers will be paid, and they agreed to pay 12 crores upfront.
How that figure of 12 crores comes is also I'm not very sure. Because according to the RP, he filed an affidavit in which he said
that we'll hear Mr. Radhi on this point.
Well, can I just 2 pages of the application that they have filed?
Point we'll have to finish this matter. No problem, it will go beyond Dashera then. It will never get over.
I agree, my lord. Just 2 pages.
No problem, it will go. Find a bench, we'll find a bench. Yes.
No, my lord.
I just thought that I don't want to press too much. I just want to show that what was given to me under the earlier order, under the order of 21st of October 2022,
yes,
has actually been taken away by this subsequent order.
Oh, I see. What is the order of 21st of October? Where is that order?
My lord, that order is on page 453 of my appeal paper book.
How much is payable under this order?
My lord, what was payable under this order as per them is about 225 crores.
And according to you?
225 according to
page 289 of this paper book.
That 289 is actually what and above. The actual amount that they say, they admit, which is payable as per the SRA.
21/10/2020 or 22 order is at 425 PDF, and this finding is at 510 PDF.
What I want to show is actually page 420. 420.
Which was admitted was about 289 crores.
It was, my lord, but out of this, the gratuity of those who have been demerged into AGSL is not to be paid. So that amount will then get reduced. So, my lord, if we go by what the SRA says is payable, so for that, if my lord will kindly have the look at my paper book.
Para?
My lord, my paper book, page number 791. Where does it start? 791.
What are you reading actually?
My paper book, man.
No. What are you reading from?
Their application, which they filed, saying that they be permitted to make the payments within 5 years.
So SRA made an application.
SRA made an application.
Then what happened on that?
My lord, in that application, what they say is that the amount which is payable, according to them, is 225 crores. And the breakup of that is 14 crores of Provident Fund, 188 crores of gratuity, and 24.4 crores of damages imposed under the Provident Fund Act.
14 crores PF plus 225 plus 188 crores gratuity.
188 crores gratuity, 14 crores of Provident Fund, plus 24.4 crores of...
Repeat it again.
Yes, madam. The amounts are 14 crores of Provident Fund, 188 crores of gratuity, and 24.4 crores of damages under the Provident Fund Act.
So they said 225 crores.
It's 225.
And they undertook to pay with it within 5 years.
Within 5 years. They said we'll pay the Provident Fund upfront that is 14 crores. For the other amounts of gratuity, they say that they want to start paying within 5 years. 2 years of moratorium. Then from third year onwards, they said that they'll pay in third year, fourth year, fifth year, 1/3 each.
Then?
My lord, then after this, they moved another application. That's the second application which they moved, in which they said that if you don't allow my first application, then I want to walk out, because my plan is then not compliant under section 32E.
Then?
These two applications are filed. The Honorable NCLAT then passes an order in August of 2023, considering these applications, in which they said that we will hear the workmen at length at the time of final hearing. And my lord, the banks also filed an affidavit on 16th of August 2023, in which they said that along with the first tranche, you must clear all the dues of the workmen. For this reason only, because every side understood the earlier order of the NCLAT to mean that every single payment of the workmen has to be paid so as to make the plan compliant. Otherwise, the plan is not compliant. Section 53, my lord, payments have to come below the payment to be made to the workmen and the employees.
Then? In the plan.
All these arguments were raised before the NCLAT. They were not considered. And only on that observation that because some amount has to be adjusted in the plan, so therefore only accept 12 crores of Provident Fund, what they say, and rest of the payment can follow thereafter. So, my lord, how is then the plan compliant with section 32E? Because otherwise the finding of the NCLAT in the first order is that the plan is not non-compliant. They said that to make the plan compliant, we are giving this direction over and above what is given in the resolution plan. And if you don't do it, then the plan will go. So you have to make the payment to me and then make the distribution under section 53.
No payment has been made. No payment has been made.
And it can't be the other way around. It can't be that 12 crores is paid to me by way of lip service, and thereafter the amount of 210 crores is paid after section 53 distribution is made, and no assets have been handed over in the meanwhile to them. What happens, my lord, because the assets will get ultimately sold. None of the plan provides that all the earlier planes are of no use. They have to be sold. The earlier stock has to also be sold. So they will take the money with them. But there's no security left. How will I get this money? So this is like putting the cart before the horse.
Let's deal here, Mr.
So that's what I wanted.
Just one last thing in this workman lodges. The plan which provided for 52 crores, when the plan was given, it provided a lump sum amount of 52 crores to be paid to the workmen, which included all the dues and the amount. The NCLAT order of 21st of October, by which the Provident Fund and gratuity has been ordered, they also said that you have to pay the minimum liquidation value, which was 113 crores. So 52 crores rose to 113 crores as a minimum liquidation value only for the workman, because the workman is higher in the rank in the priority. So one is that the amount of 52 crores became 113 crores, and then the amount was with respect to Provident Fund and the gratuity, which the lordships have already heard the council. Now what they did after the order, there was a meeting, which was MOM meeting, and they read the impugned order of the NCLAT to mean that the NCLAT has already allowed them payment to be made in third, fourth, and fifth year, which was, according to my lordships, read para 115, which is the final.
We saw that para.
Yeah, so that does not say that you have to otherwise make the payment third, fourth, and fifth year. But the meeting, the representative of the SRA says that they have to make a payment in third, fourth, and fifth year. So that's a lordships may consider.
No, my lord. Before your lordships will note my points, I want 5 minutes, my lord, to give some bird's eye view. And then, my lord, I will deal with your lordship's order of 18th of January 24, which is very, very important. An impression is given to your lordship's my lord that NCLAT has breached your lordship's order on that PBG business. How is it when the Supreme Court said that you can do it, my lord, within 10 days of your lordship's order? How is it that now in the impugned order, the same thing is given? It's a complete violation of the Supreme Court's order, is what the argument is. And I showed you, Lordship, Justice Bhushan was conscious of your lordship's order. He has referred to it and dealt with it. I'll show you how. But before that, my lord, we are dealing with an airline. Airline is not, my lord, like buying a house. You have a large number of extraneous factors, from airports to DGCA to foreign lenders. The lordships have done cases of foreign leaseholders coming and grabbing planes, etc. It's all going on. So many airlines in this country have gone to the ground. You may start from Sahara, Modi Luft, Damania, Kingfisher, latest being Go.
East West Airlines.
East, I forgot, I noted. I forgot in East West. Now, there are, two big players, Air India and, Indigo. SpiceJet is...
Deccan, Captain Gopinath.
Deccan gone. Yes, Lord is right. Deccan gone. So, Spice has 2.5% of the whole thing, which is also perilous. Their, engines are being attached in the Delhi High Court appeals against it. So, we are looking at, an infrastructure of an airline in this country. Now, an airline is not, as I said, buying a house. It has a various numbers of extraneous influences which anybody has to meet. I came forward, and it is most important to note that when my plan is to be approved under the law, the authority has before approving the plan to see whether it's a plan which is merely fanciful or is it capable of implementation. So when you approve a plan, it's not only the price, it is to see whether it is capable of implementation. That is added by the statute. Just have a look at that. It was seen, and let's give me the section. And 99% voted in favor of the plan. 99% COC, voted in favor of the plan, including the present appellant. 99% voted, and they supported this plan because the airline and the crew and the workers were going to go down the drain. Now have a look, at section 31. Before I go straight to your lordship's order, because much is said that the tribunal has breached your lordship's order. Page 31, see the first proviso. The only proviso. Provided that the AA shall, before passing an order for approval, satisfy that the plan has provisions for effective implementation. They are supposed to be experts. That is the COC. In its wisdom, commercial wisdom is 99%, and the approval, is this, and the approval is final. There is no challenge to approval. We are now in execution. There is no challenge to the decree. Most appeals before your lordships are generally on approval or disapproval of somebody or the other. That is the substance, of appeals. Today, there is no challenge to the approval which was espoused by them also. We are today in some parts of execution when suddenly, according to me, they have realized. And I'll show you how. Why they are doing it. Why is only SBI doing it, Why? There should be some reason. The reason is, what they were getting in the plan is much less as per as they are thinking today than what they would get in scrap. That is why you will oppose. Why will you oppose? Because if your kitty is getting smaller and smaller, and why it is getting smaller, I'll tell you also. It is because of their actions that the kitty will get smaller. And therefore they say drive it to the ground. That's the reason. And I heard my juniors heard the last submission that a lordship should make an order under 142 for liquidation. I've never heard of this. The law provides a procedure for liquidation. The Supreme Court doesn't supplant the law. Even if it has to go at some stage, somebody has to move a petition under 33. Not that the Supreme Court will drive somebody to the ground. I'll show that to your lordship. Now, before I go straight to their question, please note one more thing. The appeal is under section 62. 62, is on a question of law. And the Supreme Court has interpreted a question of law under 62 to be akin to second appeal. These are the words of the Supreme Court in a reported judgment that the phrase question of law, under 62, it is not a substantial question. It is a question of law. it is, my lord, held that it is akin to second appeal. Your lordship may note the citation. My lord, 2023 SCC online, SC 1529, paragraph 29 and 30. So akin to second appeal, my lord, immediately what comes to mind is section 100 of the Code of Civil Procedure. And my lord, I don't need to tell your lordships the import of section 100. Your lordship must have seen it 100 times. So it is akin to a substantial question of law, which, my lord, is elementary, is not based on a discussion of facts. It is based only on a question of law arising, my lord, from the facts. And in this case, your lordship will note that the question whether the condition precedents were met. Lord, the Chief Justice sees that, Lord?
Yes.
29 and 30, just one line. And why? Presumably because it is a second appeal. Because it is a second appeal, the Supreme Court in a second appeal will not examine, my lord, as if it is sitting under section 96. It will examine as if it is sitting under section 100. And this is important, my lord, for the reason that the primary question in the impugned order is whether 5 conditions precedent in the plan have been met or not. My lord, there are concurrent findings of 2 authorities below, and one headed by a retired Supreme Court judge, holding that condition precedents have been met. And I respectfully submit, and I'll read those conditions. They are completely, my lord, questions of fact. And therefore, my lord, it is not open to argue as if my friend has argued like a section 96 appeal to say that the conditions have not been met. Now, my lord, your lordship may have a look at the grounds in the SLP. I am not, my lord, raising it just like that. See the grounds. They were aware that conditions precedent are a question of fact. See how it is framed. Your lordship will turn straight away. My lord, PDF will be 158.
The memorandum.
Now see, my lord, quickly 1 or 2 grounds I'll show to you. CA, CB, C I will deal with. C, my lord, A and B. Because the court ignored their admitted claims is so much, it has offered a package of so much time has elapsed, etc. CB, because the court has failed to appreciate that the plan has failed and is, please mark, no longer viable. That's not the question. The question is whether the CPs have been met or not. Now C is, my lord, on a lordship's direction, which I will advert to in the next 5 minutes. CD, ignored essence of timelines, condoned breaches, condoned, my lord, extensions. Now see, my lord, the issue of PBG at 134. Then, my lord, so much were the charges payable in so much time. Then see, my lord, next point, they have to pay 1,000 crores is all wrong. I'll show you it is all wrong. But this is only to show that these are questions of fact. All of them. Yes.
Because the approved resolution plan has been completely modified by the NCLAT.
Yeah.
By giving an interpretation which has resulted in the following.
Yeah.
performance bank guarantee of 150 crores given by the SRA towards implementation of the RP has now been directed to be adjusted towards the first tranche. As per the resolution plan, airport dues and parking charges of force.
I'll show you. I'll show you what they have done. What they have done here is very important. They have been telling your Lordship for the last 2 days that your Lordship said in the order of 18th of January 24 that PBG cannot be adjusted. My Lord remembers that? Your Lordship said their word was infused 350. What you did was you infused 200
and said adjust.
And said adjust. Your Lordship said the adjustment granted by the court below in the first order against which 18 January came had granted me adjustment so as to make me compatible to meet their offer. Your Lordship said, sorry, there is no question of adjustment. It is 350 or, my Lord, in cash. So your Lordship disapproved the adjustment and gave me, my Lord, 10 more days. Your Lordship gave me 10 more days in the order from 18 January till 31st January. If Mr. Rodgi, you are still winning, the Supreme Court gives you 12 more days. Bring in that 150 and we will hold that you are in compliance with the offer, in which case everything, my Lord, will come to an end. Your Lordship, remember that? And I'll show that. I could not bring that money. That offer in a pending appeal in enclave came to an end. If that offer comes to an end, that PBDG adjustment which I wanted also came to an end.
No, if you had complied with the order,
then my Lord,
in which case, then you would have had, then they would not have pressed their challenge against the extensions which were granted to you.
Correct.
Now, if you
they
don't,
would not, my Lord, both. They would not have even questioned the completion of the conditional precedent.
Right. Now, due to your failure to pay that 150 crores,
yes,
they are now, it's open to them to argue that you have not complied with the conditions precedent one.
No, my Lord, no.
And second,
that
you should not be granted the benefit of any extensions that you got and concessions that you got.
That's the rub now.
And minus them, there is clear non-compliance.
Minus without conditional precedent, nothing survives. Now, this is very important. Let me explain it again. Let me explain it by some dates, if you're not familiar.
But Mr. Rodgi, when we said you have to deposit 150 crores in 10 days, after which an application for extension of time was filed before us, we rejected it.
Correct.
And yet, your client doesn't comply.
So therefore, my Lord, what is the consequence? What is the consequence? The consequence is only one. That Mr. Rodgi's client will not be allowed the benefit of their offer in the appeal.
And what is the affidavit in the pending?
Yes, I'll show you. And therefore, my Lord, your Lordship's order is very carefully worded to say that this is an interlocutory appeal in which an offer is made. If you accept the offer, then this will happen. But if you don't accept or you are unable to accept, we will relegate you to the pending appeal by them against, my Lord, the order of, my Lord, complying with the conditions.
25 substituted. Sorry, 25(1) says violation will lead to Lord, consequences resolution plan, not consequence affidavit.
How can an interim settlement, Lord, if a Lordship don't grant me a stay, say in a money decree,
substituting,
or in a decree for possession, it is executed. If I win the appeal, I will get it back. No? It's not that the Lordship not.
Our order said failure of compliance, the consequences under the resolution plan will fall.
The resolution plan will be on merits with the appeal is pending. It can't be that by an interim order, if your Lordship refuse an interim order, the appeal is dead.
What was the offer which they made?
I'm now showing you. They're very, very important. My Lord, that's the whole rub. They are mixing up the PBG, which I wanted as a part of an offer to the settlement, as opposed to the adjustment of PBG, which is available in the resolution plan at a particular point of time. Quite clear, my Lord. That's the importance. And they're different. Let's now start with that. Kindly note, my Lord.
Sorry for the interference. He has to answer two things, my Lord. He was not there when I said.
My friend should not
sorry for the.
ask me at every stage.
I'm not. He said two things to your Lordship.
At
he
every
was not
stage,
there. One is the consequences resolution plan will follow. Alternatively, if they agree, or if this court says no, this is only an infraction of the affidavit, he is entitled to argue on merits. He showed a list of effective dates. even if you go by the merits, having not the condition precedent is you should execute the mortgage first and then release the PPG. Whereas the tribunal passes an order on merits, you release your bank guarantee and then execute the mortgage.
Absolutely.
What has happened today? You have released the bank guarantee, mortgage has not happened.
One second.
So we have also argued this alternative without prejudice. My friend was not there. I have to. Both ways it is, both on affidavit and on merits. My lord, PBG could not have been adjusted is our case. We have argued both ways. My friend has counseled both.
18th January. I am on 18th January. I have yet to come. Today, what has happened? Now, in that, my lord, just note two things.
Yes.
My lord, on 13th January 23, very important. The NCLT held that CPs are met. I am using, my lord,
Yes.
CP. 13th January, CPs are met. And the time, my lord, for implementation is extended till 15/5/23. And at this stage, your lordship may note, it is my case that CPs were met on 20th May 22. Actually, that should have been the first date. It is my case that they were met on 20th May 22, and therefore that is the effective date for implementation of the plan and the timelines to run thereafter. This was affirmed on 13th January 23 by NCLT. Now, my lord, they do not accept this position. There is no gainsaying that even if it was met, what did my clients do? Till today, they do not accept the proposition. Till today, they do not accept the proposition that the CPs are met. So there is no gainsaying that what have you done for the last 2 years? Because you don't agree to the, if you don't agree to the starting point, we can't reach the end of the race. And why I say, my lord, they don't agree till today? They filed an appeal against 13 January in NCLAT, saying we do not agree that CPs have been met. That appeal, my lord, was appeal number 129 and 130. It was filed within 10 days, that is 23rd January, saying we protest against this finding that CPs are met. They filed the appeal, my lord, with a stay application. They came up on 3rd March. On 3rd March, my lord, NCLAT declined to pass a stay. That is PDF 704 to 714. I don't want to read it. Just kindly note that. Aggrieved by non-grant of stay, they came to this court, my lord, on 17th April, in a month, and they filed civil appeals 373637 by 23. Now, the second thing which came to this court, my lord, was on 26th May, time for implementation was extended up to 31st August. And on the same day, an injunction was issued that PBG will be invoked only with leave of the court. Against 26th May, that is for extension an injunction. They filed appeals in this court on 3rd July. 4131-4134. Now, in the pending appeal, which is the first one I mentioned, my lord, in NCLAT, because the NCLAT appeal was still pending, only stay had been refused. I hope your lordships have got that.
Yes.
So only stay was refused, matter was pending here. The appeal was pending in NCLAT, holding that CPs are complete. In that appeal, my lord, an affidavit was filed, which I call it, my lord, an affidavit of offer. Wait. Let me finish the issue. An affidavit of offer was made in the pending appeal before NCLAT, dated, my lord, 16th of August. In that affidavit, my lord, is at PDF 738. Your lordship may see the affidavit. 738. 738, you said. You said 738. Actually, my lord, it will be at 732, not 730. Your lordship may note 732. Kindly, my lord, straight come to.
Is it in the main diary? Is it in the main diary?
Yes.
734 PDF is an application under Rule 11.
That is by the consortium. That's the application under the consortium.
My lord, 730.
730.
730. It's an affidavit of one Prashant Singh.
Yes, got it.
Lordship has it? Yeah.
Yes.
Now, the lordship may now see. Yes. Kindly turn to para 8, which will be 2 pages down. This is a para 8. In the present appeal, the lenders are agreeable. So this is an offer which came from them in a pending appeal. What was the offer? If you infuse 350, my lord, the chief justice remembers not when your lordship dictated the order report, there was emphasis on the word infuse. Infuse means cash, not 200 plus 150 PVG. That's what your lordship said. Infuse by 31, the date by which the payment is to be made, read with the order. SRA will undertake to completely follow the other terms. SRA will comply with liabilities. The lenders will not contest the issues relating to grant of exclusion of time in terms of the order which I have mentioned, my lord, which is 13 January, which is under appeal before NCLAT on that day. 13 January was in appeal on in which these affidavits filed. Passed and read the second order of 26th May.
Still has issues relating to CP.
I read that again. The lenders will not contest the issues relating to grant of exclusion of time. The lenders will not contest the issues relating to grant of exclusion extension in terms of the orders of 13 January and 26th May. Both these orders were in appeal ultimately, passed by the tribunal, as well as on the issue of compliance of the CPs, and undertake to withdraw the appeals, so and so, so and so, so and so. In other words, last they will not contest, etc., etc. So, my lord, it's an offer by a party pending an appeal. That's all. It's an offer, my lord, by a party pending appeal. If you comply with my offer, Mr. Other Party, then the appeal itself will be disposed of on consent. Simple. It's as simple as that. So I call it, my lord, SBI's affidavit of offer. It is capable of acceptance by my client. But what my client did was, he did not infuse 350. He infused 200. And he told the tribunal, please hold that I am accepting the offer by 200 plus 150 ppg. So, my lord, it was in one sense contrived, because either you accept 350 or...
see the last sentence of their application.
Yes.
Failing to comply with the conditions mentioned in paras 8A to C above, the corporate debtor should be directed to go into liquidation. We said that failing compliance, the consequences under the resolution plan will follow.
And also 8A, 8A, 8A.
Please. Now it's like this. With respect, it's like this. A party says, pending an appeal, if you accept my offer, the appeal is settled. If you don't, the appeal is then dismissed. Is it ever possible? I rephrase the question. Two parties are litigating. One comes with an offer. The lordship said, look at the offer. Are you willing to do it? I try to do it. But the man who offers says, if you don't accept, the consequence is that your appeal will stand dismissed. Who is he to say that?
No, but the appeal was by him.
No.
He would say that if you don't comply, my appeal will stand allowed and you must go into liquidation.
I say my appeal will stand allowed. It is the other way.
No, what they said was this, that the NCLT had held that there was compliance with the conditions precedent.
Yes.
Right? Second, they said that there was compliance with the condition of infusing 350 crores by adjusting the performance time guarantee to 150 crores. Now, they said, if you bring that 350 crores upfront and you follow all the other terms and conditions and you pay to the workers, they will not really press their appeal. All right? If you don't comply, the consequence, according to the consequences also, then that you argue your appeal.
What else can it be, Lord? What can it be? Can it mean that my appeal will stand allowed? I've never heard of this, Lord. There's an acceptance offer.
But our court, we did not give you an option to pay the 150 crore. We directed you to pay the 150 crore.
Just bear with me for 2 more.
Right. Which meant one thing. When we directed you to pay 150 crores, it was not an option.
But that is where you offer.
But if you then, obviously, if you don't pay that 150 crores, then you are not in compliance with the plan.
I still am. That's what I have to show. I agree with you. So the short point is, at this stage.
Otherwise, why did we say in our order that the consequences under the resolution plan will follow? There had to be some consequence in your client. Otherwise,
also read an interim order, or can we read an interim order to say that if you don't accept their offer, your appeal will stand dismissed or allowed? How neither a court will do that, nor a party will say that if you don't accept it, you will be deemed not. My appeal will stand allowed.
No, basically what they are saying is this in their affidavit. If you comply with these three conditions, namely 350 crores, all other conditions of the plan and workers' dues, we will then not contest our appeal and we will take it that you have complied with the conditions precedent, that you have complied with the conditions precedent, and therefore the plan must be implemented. Now, the conditions which they set were not conditions divorced from your obligations in the plan. Under the plan, you were required to pay 350 crores upfront. They said you first pay the 350 crores. Now, it can't be that you don't comply with the condition of paying 350 crores and say, yeah, I will still argue whether I am in that fund.
With great respect, but please, I can't have a dialogue every minute. So, my lord, when your lordships.
That is not a way a party can treat the Supreme Court's order.
Let's see the order.
When the Supreme Court says you pay 150 crores, you better pay that 150 crores. And that's how you understood it. Because you asked for an extension of time.
It's a part of the offer.
Because if you ask for an extension of time, otherwise you would have said, all right, I have not accepted your offer. You argue your appeal on merit.
That's what the Supreme Court has said. Please allow me to show that. Your lordship's order is very carefully worded. It is not, my lord, what they are telling you. We'll go by the order.
Yes.
And why I showed you this, my lord, was to say that no court will pass an order at an interlocutory stage which will have the result of dismissing or allowing an appeal. It is contrary to our jurisprudence.
So it was a with prejudice offer made by them that if you comply with this, my appeal will be dismissed.
Correct.
Effectively.
If I don't, does it mean it will be allowed?
Depends on what parties agree.
I never agreed that if the offer is not met, my hands will be tied and I will be standing in a position, my lord, where the appeal will stand allowed.
See, Mr. Rodgi, the basic non-compliance was your inability to pay 350 crores.
No, I'm sorry.
Now, if you have not complied with that, everything else, workers' dues, etc., all shades into insignificance.
That issue.
Therefore, you had to pay that 350 crores.
350, my lord, in terms of the plan, not the offer. And terms of the plan are different than the terms of the offer. This is what I want to show. And therefore, the interlocutory position cannot finish my life.
First two tranches of 200 crores, you paid on time.
Yes.
When was the third tranche of 150 crores due?
Yeah.
Under the plan, when was it due?
30th September.
No,
30th September 22, right?
Let me tell you now. That's very, very important. Please, no,
you were in default because you had not paid the third tranche by 30th
Just bear with me for a minute. Bear with me. Somebody says, I don't accept compliance of the CPs. Right? That happened, my lord, on 20th May 22. I have to bring the money after 180 days of that period. But the other party says, I don't accept that you have not completed the CPs. If you are saying that you have not completed, what's the point of going on bringing monies? I brought in 200. Even till today, they are arguing before your lordship. We are now in end of 24. They are still arguing that you haven't met the CP.
We got your point. Your point is that, look, they made a with prejudice offer saying that if you comply with these conditions,
this will happen.
I will not contest my appeal. If you don't comply with it, the consequence is that they may contest the appeal. That's all that you are saying.
It is not my argument only. It is evident from a lordship's order. Now turn, my lord. In other words, the time to put in that 150 in the plan has not come even today. Because if it will only come when party on without the effective date of completion of the CP, which is 20. You are contesting till today. You are contesting till today that CPs are not met. 200 is down, my lord. In any case, what's the point of that 150, my lord, when you go and contest the starting point of the race? What's the point of saying? I heard my friend say, oh, you now said 20th May, see what you have done till today. 20th May, 2.5 years have gone by, my lord. You do not accept till today that CPs are met. I had the airport operator certificate for 1 year. He said, you haven't renewed. Who will renew? You don't have a plane, I don't have the company, I don't have the crew. Which, my lord, DGCA will, my lord, renew my certificate. I had 48 slots. Can I go back to the airport? With what face will I go? I don't have a plane, I don't have crew, I don't have the company. What will I do? So, my lord, the point is, if you are struggling at the basic point, have you or have you not met the CP, there is no point of talking of 150 crores. And I will now show you, my lord, for the lordship's order, that your lordships were conscious of what I am arguing, and that is reflected in the order. Come straight, my lord. Come straight to your lordship's order. The relevant part, my lord, is, my lord, paragraph 17 and PDF 852.
Of the main diary?
Yes, my lord. Because it is said again and again that the enclave has breached your lordship's order because I did not pay. It's internal page 10 of the order. It is again and again argued, my lord, that enclave has breached your lordship's order in granting adjustment today when the Supreme Court refused adjustment then. As simple as that. Now kindly turn to, my lord, para 17. The lordship will find, see, my lord, the arguments 1 and 2. I don't need to go any further. 1 and 2. My lord, say para 17. Mr. So-and-so submitted by affidavit of so-and-so. This is the affidavit of offer. SBI had stipulated 3 conditions. My lord, the main one was infuse 350. B. 2. The plain meaning of the word infuse is that SRA was liable to pay the 3 chances. That is 100, 100, 150. And enclave was not justified. Please mark, at the interim stage in permitting adjustment. This is how both of us understood this case. Why? Because, my lord, appeal was pending, and an offer pending the appeal can never have the consequence of deciding the appeal one way or the other. Now turn to 19. In the light of this is what your lordship said. Clear as daylight according to me. Para 19. While considering rival submissions, it must be noted at the outset that the appeal stemming from the order of 13.1 holding that SRA is compliant with the CPs is pending before enclave. Hence, the observations in the present judgment are confined to the arrangement which must operate during the pendency of the appeal without this court expressing a final view on the merits of the appeal which is pending before enclave. My lord, it's clear as daylight. And I respectfully submit, neither this court nor the other party can argue, my lord, to the contrary after para 19. So para 19 is clear. Which is, I'm going to read, which is, my lord, and I paraphrase. Mr. Enclave, you allowed 100 plus 100 plus 150 of PBG as a condition of acceptance of the offer. The aggrieved party comes here and says, sorry, it should be 100 plus 100 plus 150 in cash. No question of adjustment, so our offer is not met. And the enclave is wrong in saying that the offer is met. Or in other words, the offer was thrust upon the appellant in a modified fashion.
That's wrong.
This is what my lord enclave did. This, my lord, is the lordship's order. Now, my lord, kindly see. Your lordship then finds 21. Now 21. Again, para 21. Now see para 21. My lord, third line in para 20. Now turn below. Sorry. Still it is.
not altered the condition through the affidavit.
Again,
We want to clarify that. My friend can answer.
Mr. Venkatraman,
Yes.
his point is very simple.
Yes.
It's simple
He said-
point I'm
He
saying.
says that if they were to comply with the three conditions
Correct.
which were specified in your affidavit,
Correct.
then you would not press your appeal that there was non-compliance with the conditions precedent.
Right.
But if they didn't comply, that would not mean that your appeal is allowed.
That's all. It's as simple as
We have to still, therefore, the heart of the matter is, has there been compliance with the restriction plan?
correct. I will come to that.
So let's go to that.
And let's go to that.
Go
So
to that.
I'm very grateful.
Simply
So
go
I
to
just wanted to say para 21. Below middle of the para, your lordships again do not use the phrase. And consequential release of the PBG at the interlocutory.
And the third in paragraph 25 is very important. Whether or not the SRA has been compliant with all the conditions of the
Correct.
restriction plan,
Correct.
as well as the conditions set out
Shall
in
be
the stage of the
I'm
application
grateful.
decided by the MCL in class.
Shall be decided. So now they have decided. Whether they have rightly decided or wrongly decided
Is what we have to decide.
which your lordship will decide.
Now show us on.
Now I go straight to
Now
that.
show us the
Correct.
resolution.
I wanted to get out of this without to show that NCLAT has not breached your lordship's order in allowing the PBG adjustment today, which is different from the PBG adjustment which I wanted in the plan.
That doesn't necessarily follow. That we'll take a call. We'll hear you on that. But
I'll show you.
on whether the NCLAT could have imposed conditions at variance with what the Supreme Court had.
No, Supreme Court's order was interlocutory. It said decide the appeal. But with great respect. No, with great respect. My lord, two different situations. With great respect, my lord. There are two different situations.
They have to comply with what we had said. You may, I mean, you are right in saying perhaps that look, if I don't comply, then let appeal will be argued, no problem. But NCLAT, while imposing fresh conditions, can't do something contrary to what we had.
Yes, my lord, your lordship's order was interlocutory that PBG cannot be adjusted in payment of 350.
All right, we'll see that. We'll see that.
But if PBG is adjustable in the plan, then why not?
Subordinate to us.
No, it is not insubordination. Would you think Lord Justice Bhushan will write a 50-page judgment without
Nobody does that
insubordination
intentionally.
of the Supreme Court? Can never be.
Nobody does that intentionally. We have
Nobody
to
will do it. No.
There is an error.
And things of Justice Bhushan we have seen here for a number of years. Now we go, my lord, straight to the conditions.
Yes, let's see the plan. The plan.
I'll now show you.
First and foremost, let's see the plan. The issue about the performance bank guarantee.
So now we go, my lord, straight to
The tranche 1, 2, 3, 350 crores plus performance.
I will go straight to that. My lord,
And when will the performance bank guarantee be received?
5 CPs, my lord, are not only in this tranche, there are separate CPs.
Yes, yes.
Yeah. So I want to give you, my lord, give me the chart.
The airline
There
operators,
are 5 CPs.
AOP, slots, workmen's dues, airport dues.
So now, my lord, let me for a minute tell you, lordship, my lord. On the workman dues, though we'll come to that later.
Let's go first to the tranche, the first
All right.
payment. That's the most important.
We'll go. Thus, it's 5 CPs. So straight up. See.
6.1.
Beloved, your lordship may note, before I read it, tranches are not a part of the conditions precedent.
Later.
It's important. It is after the effective date.
Let's see the plan.
Yes. Beloved, just see these 5.
Let's
go straight to the
We'll go first to the plan. I think.
I'll go to the plan.
Yes.
Just have a look at this 5, then we go to the plan. Don't see anything else. Beloved.
Validation. Yeah.
Validation of air permit, submission approval of building plan, slot approval, international traffic, demerger. Now, the other side talks about A, C, and D. You also mark A, C, and D.
Correct.
Kindly mark A, C, and D. That's correct.
Correct.
Now A is validation of the permit. My lord, just allow me 5 minutes, then we go to the plan. It was granted to me, my lord, on 20th May 22, which is the date of completion of the CP. Kindly mark that, my lord, on the top. The first line. 20th May, it was granted to me, my lord, valid for 1 year. On 20th May, which on that day, I said all conditions are met. Now, there is a lapse of the AOP pending an appeal. Because, my lord, 2 years have gone by. How can I keep it going on and on when you are contesting the whole thing right from 20th May? I can't renew in, my lord, an ideal or a useless situation. So that is one. Now see two. Submission approval of business plan.
Not contested.
So that's not it.
So leave that. Now come to C. Up to the effective date, which is below 20th May 22. Kindly put it again in C below. Effective date and date of completion of below the 5 conditions is the effective date. So up to 20th May, the date I say that I have complied, below I secured 48 slots in Delhi and Bombay and others. Now, which airport will give me slots today or renew the slots when you say you don't have the company, you don't have the plane? And slots below vary from year to year.
Subject to payment of airport.
Mr. Please.
So how-
Now see D.
That is not there.
D. Below D can't apply because the law is to apply for international traffic rights, you have to get a minimum 20 planes flying domestically. That is the requirement. I don't have a single plane.
6 planes.
Or 5 or 6 we have. So D, my lord, in any case, has been held. And now CE is not disputed. So A, C and D. Kindly, my lord, mark. Now see, my lord, A, C and D. Your lordship has D. International traffic rights is required to be obtained in compliance with applicable law. Clause 8B of the Civil Aviation Policy requires a minimum 20 aircraft to be deployed for domestic operations before applying for international. Thus, this CP can be fulfilled only when you commence. And when will I commence? When I get the company. And that is how, my lord, it is actually A, C and D. These are the 5 conditions. If your lordship desires, I will now show from the plan.
Let's see the plan.
I show from the plan. My lord, in the remarks I mentioned, your lordship will see the remarks. Let us go straight to the plan.
PDF page number bata do.
Now come, my lord, to the plan to show you what is this ABCD. My lord, 286 PDF. And I dare say, my lord, these are simple conditions. I met them. Why? Because the day I got the AOP, that day, my lord, I completed. Because D doesn't apply, C I had, and A I got on 20th May. That's the rationale of 20th May, my lord. My lords get that, my lord. The rationale of 20th May is the grant of A. Because C I have got and D doesn't apply. So these are simple terms. They were not some convoluted terms, my lord. As simple as this. Now your lordship wanted to see from the plan, kindly, my lord, turn. And on this, there are concurrent findings and there are simple findings, my lord. They are not convoluted findings. AOP on 20th May. Slots you have. International doesn't apply. read below the plan, just allow me 2 minutes to read the consequences. Kindly take up my chart for a second.
Yes.
I read to your lordship A, C, and D. They're very simple. Now see the consequences, Milord. My lordship Mishra has the chart. See, Milord, I read A, C, and D. See the consequences. SRA will not be able to recommence operation as an aviation company till I get below a validity of this AOP. Now see C. C is important. Slots. The resolution applicant to complete CPs within a maximum period of 270 days. If CPs are not fulfilled within such period, the resolution plan will stand withdrawn. On the withdrawal, member of the resolution applicant shall resign. Remaining members shall assume control. Now see, my lord, D. This is, my lord, what was in D. And let's see the last now. This is very important. So, my lord, there was a demerger between JET and a subsidiary company in which some operations were hived off. Now, the approval date of my plan is 25th June 21. Now, see, my lord, the consequence. The effective date, 90th day from approval, subject to extension. What I had done was, I had made, my lord, these 90 days to 270 days. But they said 270 is too much. So when they're granting me approval, they said 270 is too long. We will make it 90. You come back to us for extensions. So the consequence of 270 will be very harsh. You come back in 90 and then do whatever you want to do. Now come back, my lord, for a second to page 286. That is why there were extensions, and I will take your lordship to the extensions also. I'll take your lordship to the extension. Much was said about extensions. All extensions, if your lordship desires, your lordship can note and I'll show. All extensions up to the effective date are supported by them.
Yeah, you don't deny it.
Yes. I'll read it. I'm going to read it. So there are extensions, my lord, prior and extensions post. Till 20th May, there was a support. 20th May, they challenged, my lord, in NCLAT, and they started obstruction. And therefore, my lord, at every obstruction, there were extensions granted by finding that I am in the right. Now, my lord, have a look at, I'll show those extensions later. Come to 286. My lord, 7.6. 7.6. At 286 bottom. Your lordships get conditions for implementations, condition precedent. The first is AOP. Same in my chart, my lord, I am not reading. My lord, your lordship, see there, I don't want to read, my lord, it's a part of my chart. My lord, seen that? Yes. AOP in my chart is also item A, this is also item A. Come to C, my lord. C slots. That is C in my chart. At 48.
Subject to payment of 475.
But one sec, please don't interfere. Please.
Finding is,
what kind of payment should I make when you are litigating at every step?
No, your NCLAT has said.
Now,
your NCLT has said.
Now kindly will not turn.
Subject to payment of 475. Let them assess the court properly.
Where is the subject to payment of sir?
Both, please see the finding.
I'm going to show whatever it is. My friend should have patience.
It's not here.
It's not there.
I show you. My friend is having disjointed effects. That's why, Lord, he made 18th of January the lordship order as if it's in breach of the
page 124
is in breach.
Page
That's what he
124 PDF. Page 124 PDF of NCLT
wait now, please.
says on
My friend will have a chance in disjoinder or no?
Which is 475.
He will have a chance in disjoinder. He should wait.
Yes.
I have yet to show you what was the salient plan in terms of money, my lord. I still have to show you.
Yeah.
It is not this 350 only. The whole thing, my lord, is wrong. Every fact is disjointed. Now, my lord, turn to turn to D.
3:25 p.m. on a Tuesday afternoon. We can also do with a little bit of shaking up in the court, you know. So
I can continue on Thursday, my lord.
No. We'll continue. So we don't want to break your link, and you're in the thick of the matter right now. We are there.
No, I don't mind, my lord. I can do it.
No. We are actually in the
yes, right. So, my lord, the condition precedent is A, C, and D. I have culled it out for the lordships, not in the chart. Now, this A, C, and D, my lord, as I read, was in compliance with applicable law. And applicable law, I have given the policy that unless you have 20 domestic jets, and that too, my lord, if I remember correctly, for 5 years. The policy used to say you must have 20 planes running in India for 5 years before you're allowed to go abroad. That's why Indigo didn't go abroad for more than 5 years. I know for a fact. I did that case, my lord, for them. Now, my lord, see the fulfillment. 762. The date of fulfillment of the CPs as stated above shall be the effective date. So the effective date, my lord, is 20th May 22, which is, my lord, this first approval from the AOP.
How do you interpret this clause, Mr. Rodgi, according to you? 7.6.2.
Yeah. The date of fulfillment of the conditions precedent. That is, whenever you fulfill A, B, C, D, E.
That fulfillment will be for all times to come.
Yes, to stop. Yes, Lord. On that day, the issues of renewal are not, as I understand the question, the issues of renewal of the AOP or the slots.
Not renewal. Just for our understanding.
Yes.
Take the case of validation of the air operator permit AOP.
Yes.
You said you had this for 1 full year.
Yes.
Then it expired.
Yes.
NCLT in its order says, well, it has expired. We are drawing your attention.
Yes.
Now get it renewed.
I will.
So therefore,
so the problem is,
can it be argued today that since I had this on the effective date, it continues today also?
No, my lord, DGCA.
So if it doesn't, are you compliant with the resolution plan? That's the short point.
Let me explain, Lord, again. I understand the point. Lord, this clause clearly states.
7.6.2 is little baffling. Just make us understand. What do you understand?
Actually, Mr. Rodgi, what I think what would happen is this. Once the conditions precedent are fulfilled, then the effective date kicks in.
That's what I'm saying.
Completion of the condition precedent is tagged with the effective date.
Correct. That's all.
Effective date arises on the date that all the conditions precedent are fulfilled.
So they were met,
which got modified. Which got modified in para 33.
Another thing.
So now
another thing, the obligation to fulfill the conditions precedent is cast on the SRA, that is your client. You are the SRA.
And these are my conditions.
Right. These are therefore 7.6.4 says, now let's see 7.6.4.
Yes.
You say that I will comply with the conditions precedent. Yes. Effective date was not defined as a particular date in the plan.
Yes.
Effective date is the date on which all the conditions precedent are fulfilled by you.
Yes.
Now, you say that I will complete all the conditions precedent within 90 days.
Correct.
That means the effective date has to take place within 90 days.
Perfect.
In the unlikely event, I can't comply with it within 90 days, 180 days. And then finally, if you don't comply within 270 days, a plan stands automatically withdrawn.
It's sent to liquidation. That's the time.
Right? Now see 7.6.4. Therefore, actually, effective date was not defined. The effective date was not defined as a particular date.
Correct.
Only
Why?
Because it varies, my lord.
It could vary. Right. Because you had to comply with all those conditions precedent.
Yes.
Once you complied with those conditions precedent, immediately the effective date would come in.
Right. Therefore, NCLT fixed it in para 33. First order of NCLT.
My friend,
para 33.
My friend
fixes a 90 plus 180.
He will have a chance to argue later. Why you not? Right. So you're actually right. The effective date is the date when you comply with ABCD put together.
Right.
Right. That date, my lord, in this is 20th May 22. It's as simple as that. Have a look again.
Correct.
See again ACD.
But is it admitted that the effective date is 20?
No,
this is what
there is no difficulty.
Must allow me.
I'm agreeing for change. I'm agreeing.
No, please don't agree.
So
now
both sides agree that 20th May.
No, they filed an appeal.
Yep.
So today
well, we have not filed an effective date. No. It's a wrong fact. Because I've agreed.
At the relevant time, did they agree that?
And therefore they filed appeal.
No.
That was in my favor. That's the rub. If parties agree, Lord, it's very important. This question is most important. If parties had agreed that 20th May 22 is the effective date, it is cast in stone, and then we see forward. They did not agree to 20th May. Then they filed an appeal to NCLAC. They failed. They have now filed an appeal before the Lordship.
We have not sought extension. We agreed 25 as the date and said they are non-compliant. Therefore, go for liquidation. We said we agreed on the date.
No, but Mr. Rodgi, if they accept that 20th May 22.
They never accepted. What do you mean accept? They never accepted. Till today they have appeal. What's the point of saying I have accepted?
No, one second.
Yes.
Fair enough. We'll keep SBI out of the picture right now.
Yes.
But if you are of the view, if your clients took the position that 20th May 22 is the effective date, then surely you had to start implementing the plan on that basis.
I started, and I'll show you.
For instance, you had to mortgage property, you had to infuse funds.
I'll show you all that, but at every stage, there is a wall. Then I don't accept 20th May. What's the point, Mr. Rodgi, of talking plus 180, plus 90, plus 270? If you are not accepting 270, then what should I do? I should go on getting money. I brought in 200 crores more.
Eight 21, I write to them next day saying, I have complied, let's start.
I'm going to show you all that. I will show you. Milord, I will show you. I am now going to show you, Milord, after this, that when I said 20th May 22, as my Lord Chief Justice said, if you have complied, then you have to move forward. Right? To move forward, I need their assistance also. Milord, in other words, to move forward, I need their cooperation also. And I start in the right earnest on the next day, 21st May. Till today, and I repeat, till today, they do not accept that 20th May 22 is the date when you have successfully got the conditions precedent. Because they challenged it in the appeal I have given your Lordships. They didn't get a stay, they came to this court. Your Lordships decided on 18th of January. Then it went back. When it went back for the main appeal, resulting in the current impugned order, there also they don't accept that CPs are met. It is argued before your Lordship today by the other side that CPs are not met. So there is no point, my Lord, again saying that we are all agreed as if, my Lord, in hindsight on 20th May, we had all agreed. Not at all. And I will now show you, my Lord, what happened after 20th May in terms of timeline and in terms of what was happening. And what was happening. Now, my Lord, your Lordships, before I do that, my Lord, the Chief Justice had referred to 764.
Yeah.
Let me read that, then we'll go, my Lord, to what happened. The resolution applicant is confident of completing the CPs within 90 days from the approval date. In the unlikely event that CPs cannot be fulfilled, the RA will take responsibility of completing the conditions precedent earlier and seeks to extend the CP's fulfillment by a term of another 180 days. If the conditions precedent not fulfilled within such period, that is 270 days for the approval, then the plan will fail, etc. On such plan, this will happen.
This was modified.
Now, can I just finish this and then go back to the floor? So this is what I did. The Lordship may note on the side and I will show. The extensions, I got 3 extensions prior to 22nd May. Please note that. I got 3 extensions prior to 22nd May. They were supported by the other side expressly in writing. And your Lordship may note those extensions. They are, my Lord, extensions dated 29/9/21 at page 402 PDF, 20th January 22, page 407 PDF, 11/4/22, page 421, para 16 thereof. Now just see one as an example. These are before May 22.
We'll take your word for it. No,
So they are there. Now just come back to 764. In 764, the last extension which I got, which I mentioned to your lordships, 11/4/22, the last extension was till 26th of May 22 is the last extension under 764, fully supported by them, and the order, my lord, is at page 421. And within that extended time, I obtained the AOP, which was the critical date, my lord, for completion of, my lord, the conditions precedent. This is what happened till 20th May. Now you have to go beyond 20th May. You have to go beyond, my lord, 20th May. So those three extensions, they were accepted. Suddenly, my lord, I don't know what happened to them.
One question.
Yes.
We may dismiss the appeal of Mr. Venkatram. What will be the next step at your...
Next steps are deliberating the judgment.
You have not paid 150 also till this point of time you have not paid.
So now, you are very, very important. 150 is one part. There are several other things. For 150.
And you argued, Mr. Rodgi, that they have been creating hindrances.
The judgment is replete
But
with
what-
their conduct in stopping me at every stage.
Yeah, but what hindrance did they create for the purpose of executing the mortgage?
Absolutely right.
Just a minute.
Yes.
Only one
I'll show you.
argument that the registration cost is to be borne by them.
No, that's not
according,
will be an issue.
according to you, we will not.
I will be here.
So what has come in your way
I'll show you.
in executing the
Yes, I'll
mortgage?
show you, my lord. It's very important. I'll show you.
Why this 150 has not been paid till this day?
Let me answer orally.
Nothing has proceeded for.
I'll show you. It's a very important question. What stopped you? Because properties are mine. I have to execute a security. As simple as that. So, I'll answer it just now, my lord, and then show you. So, my lord, the position was, I had brought in 200, 150 remained. 150 remained. Forget the interim order. I'm now on the plan. 150 remained out of 350. So the plan provided that if you gave adequate security in lieu of the PBG, as distinct from the lordship order of 18 January, if you give adequate security in lieu of the PBG can be converted into cash. It will be taken.
Let us see that.
Yes, and you will give security. So to do that, I brought in 200 to exercise my right for that.
Now, Mr. Rodgi, if you just see after 7.6.4, 7.7.1,
yes,
that is the implementation schedule.
Yes, absolutely, very important. Let's deal with it, then I'll answer the security.
The X is your declaration as a successful resolution professional. That is skill number 2.
Kindly see, my lord.
1 is the approval date. That's all gone.
Now see 10.
Now 10 effective date.
Right. Now, my lord, 8 is fulfillment of CPs as 761, which your lordship has seen already.
Fulfillment of conditions precedent.
As per 761, which my lords have seen now.
Yes, after Y. Now effective date.
After Y.
So that after
date is
now,
Z.
Effective date is Z.
Yeah.
Now
11. Infusion of 350 crores in the corporate data, Z plus 150, which is within 150 days of the effective date. You have to infuse 350 crores.
Now let's stop here for a moment.
Yes.
If the party does not accept and challenges Z, party does not accept and challenges Z, then what happens? Can it be that one party will go on implementing and the other party says, I don't accept? So, my lord, Z. So 11 is, my lord, infusion.
Was there any order of any court which said that, well, 26 May 2022 will not be treated as an effective day.
So, my lord, it's
You had to continue to comply with your obligation.
with great respect. I am not dealing with a bank. The
Next, now see 17. Payment to operational plus 175 days.
My lord, just one more thing.
Yes.
Kindly just for a second, my lord, before we go further. Kindly turn back, my lord, to your lordship judgment for a second.
Para 6.
Turn to my lord PDF 853 for 1 second.
As per clause 6.6.
My lord, turn to just 1 second.
Yes.
My lord, turn to page 853 PDF.
Yes.
This is the para 6 of your lordship's order of 18 January.
PDF may not be right.
PDF is not right.
8?
Huh?
Yes.
840, 846.
Yes.
Para 6. Last 4 lines.
Yes.
The SRA communicated with an email affirming a compliance with the requisites and proposing that May 20 should be recognized as the effective date. However, the lenders took a position to the contrary. And then what happened? On so and so, I filed an application for a determination of this position. This was done in January. The moment this was done in January, they filed an appeal. Then from that appeal, they came here. This is how, my lord, the plan got skewed. And now I will show you that out of 350, 200 went in August and September 23. Lord, what is the point of going on putting money for what?
His figure is 1164.
That's all wrong. I'll show you. What is 1150? These are there with me. Lord, the amount here is 350. And I'll show you why 350 is coming. There's no 1100 etc. So I have put in 200. My slots have vanished. The AOP has expired. This party says, I won't deal with you. I will challenge it. 200 has also already gone in August and September 23. These timelines were extended. These timelines, my lord, were extended after the effective date. They were extended and they've again been extended after, my lord, I paid in 200 also. So there is no gain saying that one party, my lord, will never agree. It will go on filing appeals and I will put in money for what purpose? I'm not getting the company. I can't get planes. I can't fly. I won't have the AOP. This is how this whole thing has happened. My lord, just the party will ask me about security. I'll tell you about security. What has happened? I'll tell you about the security. So, this is the position, my lord, which emerged from here. Now we go, my lord. Sorry. Extensions are. Now, my lord, I want your lordships to have. Before I show you what happened about the securities, my lord, turn to 263. The next page of the chart.
Yes.
See the last item, 785.
Yes.
What are their duties? It's a case of reciprocal obligation. It's not a one-way street, my lord. Now see what they have to do. Because I am dealing with so many, my lord. It's not buying the house. Now see, my lord, 785. Duties of the monitoring committee. This is the monitoring committee. After the plan, it's the monitoring committee, my lord. It's not the RP. From the approval date until the closing date, MC shall be responsible for making filings with relevant stock exchanges in relation to the plan. Next page. Make best endeavor. Look at this. Make best endeavor, like good practices, for early completion and fulfillments of the CPs, including obtaining necessary approvals wherever required for granting the licenses, slot, bilateral rights reinstated. This is what they have to do. They did not lift a little finger. Now see, my lord, see, supervise the implementation of the plan. You say, I don't accept, my lord, the implementation date, the completion date, the effect. I don't accept it. Where's the question of all this? Why will I help you with this? Why will I help you with this? Why will I help you with this? None of these things will arise if we are stuck at the starting point between us. They lifted not a little finger. Not only, my lord, not to help me, but to argue before your lordships. Look at this man. His AOP is expired. Look at this man. His plots have expired. Because they want to drive this plan into the ground so that, my lord, it's sold as scrap, because they feel that if you sell the planes in scrap, you will get more than what they are going to take. Now I'm going to show you, my lord, this 1100, 700, 350 business, what it is. So this is how, read with para 6 of my lord's order of 18 January. They took a position to the contrary, and therefore they have not.
Your contention, therefore, is that we never were eyed him on the effective date. They disputed that the effective date, and therefore there was no obligation to implement the plan.
No, my lord. No, my lord. I did my earnest best. I bought in 200 out of 350. For the remaining 150, I have a right of adjustment with security offered in the plan.
Now, we have to ask you a question there. You brought 200 out of 350.
Yeah.
For the 200 crores, 100 plus 100, you were on schedule.
Yes.
There was no delay.
Yeah, because there is an order.
Right.
Do it.
Now, why were
schedule,
you?
by schedule means extended schedule.
All right.
Yeah.
But why were you on track? Because that was linked to the Z date. Z is the effective date. It's Z plus 150, Z plus 175 will extend.
You understood the question?
Right.
Let me answer it.
Yes.
If I took a firm position that if you are litigating on effective date and I'm not obliged to do anything, I wouldn't have brought in a penny. But to show that I was always eager, and it is not only 200, I have done whatever I could, and I'll show you from the documents. My lord asked a question of security. Will not the plan provide?
See, by your conduct, you accepted that the Z date had arrived.
Yes,
because you paid 100 plus 100.
Everything.
In which case you have to pay everything else. You have to pay the charge of 150.
Do nothing. Will it mean that they will do nothing and they will go on litigation? The improved judgment is replete with their conduct. And I'm going to show that to you. So, Lord, just look at this. We fight with the basic condition. From day one, they are fighting with the basic condition.
And therefore, the fact that despite the fact that the Supreme Court granted you a further opportunity to pay 150 crores in 2 weeks.
Yes.
Of course, we see your point that look, the consequence would be very different. But we gave you an additional amount of time to pay the 150 crores. You never complained.
That was for the offer, my lord.
Accepted, no difficulty.
It would have been over.
Yeah.
There were difficulties, obviously.
Yeah, obviously your client was in difficulty. Otherwise, why would you not?
But Lord,
the whole effort to substitute the bank guarantee for the last tranche, because you were not able to raise funds at that.
But if the plan,
whoever was your financier must have said that, look, what's happening? I mean, there's nothing between you and SBI.
So, my lord,
they were not willing to show you the color of money.
But is it illogical for a person to say, my lord, that one party will go on litigating, it will not do any reciprocal obligation under this clause, and you please go on getting the money. You go on giving the money, AOP is over, slots are over, they are opposed to you. So what will, my lord, a prudent man look at? He has already put in 200, he's put in other expenses. They keep telling you, my lord, airport expenses have gone up to 500 crores, etc., etc. That is to be borne by me, not by them. I'm now going to show you what I did, my lord, in right earnest after 20th May 22. In the face of somebody saying, I will not, my lord, look at you, I will not treat it, and I will not, my lord, do any of my obligations. It is in that context, my lord, that your lordship will see now what has happened. Now, my lord, kindly see. Or in fact, let me first show you the clause in the plan which allowed me, my lord, the adjustment of PBG at that stage. for which, my lord, I said security. Adjustment of PBG, my lord, in the plan was allowed against providing security. It is that which the court has now allowed. Nothing to do, my lord, as a part of the offer. Nothing to do as a part of the offer. I repeat. So we see what the plan said. That is what I did. And what we did for getting security, your lordship will see. Then again, my lord, they said we won't look at you, we won't touch you. It was their obligation to write to RBI. It was their obligation to do so many things. We never did. 1.5 years have gone by. And we reached 2024. This is what happened. It's not only, my lord, the cost is 10, 15 crores. That's not this. Kindly see, my lord. Good. So, in other words, my lord, I tried my best to go on with the plan, post 200 crores. I wanted to create security of properties Dubai 1, Dubai 2, Dubai 3. Those securities have to be created with approval of RBI because properties are in Dubai. For that, valuation is required. My valuation is not good enough, my lord, because I am the mortgagor. The mortgagee has to be satisfied. In that context, what transpired from 21st May 22 till, my lord, 2024, when the impugned judgment was passed, because the lordships did not say anything in the 18th January order relating to this. What transpired and what happened, my lord, in the impugned judgment is what I want to show, my lord, for this 150 business.
To continue on the
because this chapter will take half.
This part is now.
Yes.
How long more, Mr. Rodri?
Lord, I will take about an hour.
About an hour.
Lord, my friend,
will be
Mr. Shankar.
We'd like to see what you did for that.
I'm going to show you. And Mr. Lord Gopal Shankar will. That's it. Lord, Mr. Mehta's opinion item, Mr. Gopal Shankar Nayan will do. I have not seen anything.
Lord, item 21, Lord, that Vanashakti. Lord, at least those IAs could be listed, Lord, either on Friday.
After the, not Friday because this bench is not sitting. Keep it after
the same thing about Kirloskar, royalty on royalty. That Silotho and that Goa, Kirloskar, lots of directed murders. It's on the list 14.
I thought it's immediately after the marital rape and restitution.
Yes, but Lordship will indicate because it's now on the list for many weeks now. It's today also on the list.
That's right. We have only kept it retained so no other matters intervened. So after this, we have that very brief matter on the Delhi Ridge that contempt.
Then marital rape and then
marital rape and then your.
Lordship,
this may be taken on Monday after reopening.
My lord, that Delhi Ridge mentioned, I'm requesting not to be taken up on Thursday, my lord. The senior who's arguing is not there.
Now, once that matter goes out, then we don't know because we are following exactly one particular.
I'm for the petitioners there. I don't know who they appear. His role, it's actually contemners.
Actually, Mr. Narayan and the other side as well.
Amicus is there, my lord. There are amicus in both matters.
And I thought who?
One in the senior.
And the attorney is there, no? Attorney is appearing in that, or solicitors appearing, or
no? Actually, advocates are there for the alleged contemners.
All right,
Lordship, please. Completion.
But Jan, you be ready, because the matter has been hanging fire. We are going serious.